I guess I'll be leaving.
Okay. Good morning, everyone. I'm going to call the Special City Commission, Joint City Commission, Planning and Zoning Board, Quasi-Judicial Training meeting to order. May we please have the roll for both boards?
Commissioner Villa Vasquez.
Present.
Commissioner King. Here. Commissioner McCool. Here. Commissioner Ramos.
Present.
Commissioner Sosa.
Here.
Vice Mayor Bradford.
Here.
Mayor Herzberg.
Here.
Board Member Bowman.
Here.
Board Member Northey. Here. Board Member Munoz. Board Member Starozic. Here. Vice Chairman Kennedy. Chairman Potowski. Alternate Member Burke. Here. Alternate Member Dr. Pfeiffer. Here. Alternate Member Rodriguez. Alternate Member Trombetta.
Okay, if there are any alternates that came in or any board members that came in just as we were calling the roll, we still have the seating here, and we'll go ahead and announce if anyone else comes in after we get started. May we all please stand for the pledge to the flag. Commissioner King, would you like to lead us? Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay, good morning, ladies and gentlemen. Thank you all the board members that came out, and thank you to all the residents that are here. And we have one of our elected officials from DeBary coming in. Hello, fellas. Good morning. So first of all, I wanted to let you know, those of you that are sitting on the floor, your mics are always hot. Your mics will always be open. So just know that you don't have to push the button. They're just always on, just so you know. And I'm going to go ahead and start out by letting Mr. Peters explain everything that we're doing today.
Thank you, ma'am. I just want to do a little bit of information for you all. Commissioners, you will note behind you there are 3 black crates. They are full of pertinent documents that you may want to access during a meeting. Robert's Rules, the Charter, Code of Ordinances, Land Development Code, all that stuff is in those crates. So there was some comments made as to availability of that information. The city attorney and I have one over here. In the future meetings, we will have one in the back for the public if they want to be able to access it. So this is part of our effort to be open and transparent and having the key documents available to people as we go forward. It is with a lot of pleasure that I introduce Cliff Shepard. I have had I'm not sure if the good fortune or the bad fortune of having worked with him in the past. I place him right up there with our own city attorneys in terms of people that I respect a great deal in the legal profession. And for me to respect people in the legal profession is a major accomplishment. Cliff is in that very small fraternity, as I would say. Mr. Shepard has made many presentations regarding quasi-judicial, and I wanted to bring him in so that we all can learn how quasi-judicial works. There's a lot of confusion. It's not just here. Everywhere I've ever worked, there's a lot of confusion about quasi-judicial. It's an important process for land use law, and Cliff will explain to you also that there is a quasi-judicial and then there's a legislative element. You all just went through a legislative element last week with the future land use amendment, and he can explain the differences. So with that, Cliff Shepard, the podium is yours, sir.
Mr. Shepard, just before you start, I just would like to announce that Board Member Munoz is here for the record. Thank you.
And Mayor, do I speak with the mask on or off?
Off is fine.
Okay.
Whatever you want to do. It'd be easier with off.
Okay. All right. Folks, thanks for having me here today. I'm used to speaking to mostly planning boards and planning and zoning commissions, and I often think, but I'm never typically taken up on the idea that it's my commissions that need it more, this training that I'm about to give. But nevertheless, now that you've got both here, and I'm grateful, the presentation is going to dovetail into that well. So for those of you who have jumped ahead, you will know that I cover your P&Z and its role specifically under your code, and what happens, for example, in a variance in the most obvious case where quasi-judicial proceedings are important and how they should be conducted. So I'm grateful for the opportunity. As John said, I have done it before a few times, so I was able to take this presentation and tweak it to your code and still cover what I think are the important topics. As I understand from John today, we're going to do this in Supreme Court fashion. If that means absolutely nothing to you, then that means you're smart enough not to watch court TV. But if it means something to you, it would mean that you're welcome to ask questions as I present and interrupt me as thoroughly as you feel comfortable doing. It's not required, but it's something you're able to do, and we can do that. All I ask is that we try to stay somewhere within the bounds of the topic, as opposed to, well, in this particular case, back on this particular day, which I know nothing about, I need to know whether we did this right or wrong, because A, your city attorney won't like it that I'm commenting on things that I have no knowledge about, and B, I don't know anything. So with that being the kind of parameters, if we stick to generally how these things are conducted, then we'll be in good shape. So assuming that I can make this work, let's get started. So my outline for today is this. We're going to cover your P&Z, which acts as your land planning agency, which is a statutory designation. We're going to discuss the significance of that. The difference between legislative and quasi-judicial hearings and decisions, and that's very important because that's how you know when you're wearing your judicial hat and when you're not. The relationship between your comp plan and the land use development code. Characteristics of quasi-judicial decisions, and I hope at the end of this presentation that those will be very easily understandable by you. Ex parte communications, very important topic to not get you, your board members in trouble. And quasi-judicial bias, another important thing. Findings of fact, and whether you actually need to make them or not, and whether you should. And best practices. So those are the topics that we do in this outline to try to make sure that you cover the full waterfront of what's involved when you sit, whether it's in P&Z or as a county commission or city commission on appeal. I note that somebody is here from DeBerry. The code provisions I'll be citing are specific to Deltona, but the general provisions about how you do P&Z or how you do quasi-judicial, they apply. So first, your P&Z board as your LPA. I understand that you folks out here are the P&Z board. In your city, you are, as is most, designated by statute and by code as your land planning agency. And that's a special designation required by Florida law, and it says essentially that your number one responsibility is oversight of the comp plan. It's not the only thing, but it's the reason you exist as an LPA. The specific statute that covers that is 163-3174. If you want to look it up, I wouldn't recommend it, but there it is for you. It is responsible to conduct comprehensive planning programs, including plan amendments, including future land use map amendments, zoning map changes, changes to the land development code or proposed new land development code, including subdivision regulations, planned unit developments. By the way, these are right out of your Deltona code. Conditional uses, zoning variances, amendments to the approved capital improvements program or budget, establishment of or changes to established community development districts, changes to proposed architectural design standards, proposed development agreements created pursuant to the Florida Local Government Development Agreement Act. Now, I want to stop on that last one just for a minute, because I don't know what you do, so if I'm way out in left field, it's okay, but I feel like it's better to cover it than not. Many development agreements, and in fact, in my cities, almost all our development agreements are not done pursuant to that act, and it's for a simple reason. I hate that act. It's complicated, it requires way more stuff than it should be necessary, and because of home rule authority, you do not have to do development agreements under that act. So if you as P&Z members are wondering, why don't we get to look at all development agreements? It's because not all development agreements come under the Florida Local Government Development Agreement Act. So what is a legislative decision? Simply put, it's the setting of policy. If you are making law, you are working in a legislative capacity. If you are interpreting law as applied to a given set of facts, you are working in a quasi-judicial capacity. And that's the easiest way to understand it. We'll get into great specifics here shortly, but that's the biggest point. So if you are creating a law that says we're going to need stronger provisions regarding, I don't know, something current like mask wearing, that's making law. That's legislative, not quasi-judicial. If you are deciding whether someone violated your mask ordinance, quasi-judicial. So what kinds of things are legislative? Well, adopting and amending the comprehensive plan. I know that last week one of our lawyers was here advocating that you not change, I think, your comp plan, and you decided to change it. And I think he probably said, if he followed my advice to you, that you could have a choice to do either one, and either one was defensible, and that's true. And the reason is because it's legislative. So whether you did what you did, agree to amend it, or said, no, I don't want to, they could threaten suits all day, but they can't win them. So that's important to understand. It's your most, it's your largest expanse of authority. And so that is a legislative decision, and that defines almost all legislative decisions. It includes large and small-scale comp plan amendments, adopting or amending the land use development code. All legislative, known as quasi-judicial or quasi-legislative decisions in land use practice involve setting policy. Should this area be zoned a certain way? Should this area, not specific property, should an area be zoned a certain way? Should a certain area of town be designated as an industrial zone? Should a certain area of town be designated for nothing but rural and residential? Those are legislative policy decisions. What is the legislative hearing process like? Well, broad notice. You'll note when you do your comp plan amendments, you have to do a map of where it's at. It's special publication in the newspaper and a posted agenda and so forth required by law. They are wide-ranging. Public hearings include consideration of pure preferences and opinions, conjecture, and assumptions. All of that is allowed in the legislative hearing process. Presentation of evidence. Anything that is relevant is what's presented to you. It's one of the places where, although people often get this wrong, petitions actually can be taken into account. Why? Because anything can be in a legislative decision. Whereas when we get into quasi-judicial, the things that most turn people out, I'm opposed to this project or this zoning or this rezoning, petitions are meaningless, as you'll see, at least legally. Politically, different story. I'm not here to talk about politics, but legally, meaningless. Substantial discretion. We're going to get into the exact legislative standard, but again, as I said earlier, when you make a legislative decision, it is almost impossible to legally challenge that decision unless, and this is the big unless, somebody's taken a bribe. And I literally mean exactly what I just said. If you're found to have taken a bribe, then the legislative decision can be put aside. Short of that, it's real hard. You can take a public or private position ahead of the hearing. This is why when political people run for office, they can say, while they run, if elected, I will pass legislation that does X. Have those people ever had a hearing? Have they been in front of the group of people they represent? Nope. Do they have to listen to those people when they get elected? They do not. Legally. Again, I'm not the politician. Legally. That is why you can say someone, if I'm elected, I'm going to advocate for a seatbelt law. When I'm elected, I'm going to advocate for a break on taxes to, certain industries. I'm going to advocate for credits to this business to bring them here. And all of those things, because they're legislative decisions. And even though you are not yet elected, once you get elected, you can do exactly what you promised while you were campaigning, and no one can complain that, wait a minute, you haven't heard the evidence yet, because it's legislative. It is subject to the fairly debatable standard of review. And you'll find, as you probably have already in speaking with your own lawyer, that we create in the legal profession terms for things that just tend to confuse. Here's what fairly debatable means. If you and I can have a disagreement at a bar, or not a bar, wherever you want to, if we can disagree about it and you can have an opinion and I can walk on and say, well, we respectfully disagree, that's fairly debatable and cannot be overturned. If it's not fairly debatable, I have a hard time coming up with an example of what that might be, at least in the realm in which you work. So if there's a reasonable basis to support the action, regardless if you have personal bias, not bribery, but bias, doesn't matter. If you say the reason I'm supporting this is because this happened to me once and I'll never ever do anything other than this thing, doesn't matter. Because it's not matter why you're doing it, it's whether objectively the thing you're doing as a legislative decision is reasonable. It's a very deferential standard. It's akin to a bar debate, as I've said previously. The courts may not second guess the wisdom of local government's action and must affirm if there's any reasonable basis for the decision and that there are no constitutional violations. So again, the bar for holding up legislative decisions very low. When you apply those legislative actions that you've taken to a given set of facts or circumstances, that's when you're in the realm of quasi-judicial. So if I come to you, for example, on a variance or a rezoning, those things require that you look at your own code and your own comp plan and apply them to the facts as presented by the project in front of you and determine, does it meet those standards by something called competent substantial evidence. And in these cases, it matters a lot what you say and do and think outside this chamber. In these cases, you're supposed to keep your thoughts and your mouths shut. And that is where the most trouble comes for elected and appointed officials who don't understand that basic difference. And I understand why. When you're in the political world, you're used to talking to everybody. And it's not real easy to go to a constituent and say, I can't talk to you about that. Because whatever you might know is the actual reason you're doing it, your constituents don't necessarily appreciate that that's the fact. But it is the fact. And if you want to avoid getting sued, you need to find a way to walk that line. Again, if you're applying the code or comp plan to specific properties, you're in quasi-judicial world. You cannot create new policies to govern the decision. In other words, if you have a project in front of you that you know doesn't meet your code, the solution isn't to just say, yeah, but let's bend it this time. That's what variances are for. This is not, and the answer is if it doesn't meet it, you can't change your code on the fly. It is or it isn't. You can say no and then change your code, but you can't say, yeah, but we like this developer, we like this development. It doesn't really fit, but let's shoehorn it in there. You might get away with that and might get away with it for a very long time, but if you get sued on it, you'll lose. It's site-specific applications of land development regulations, examples, as I've said, rezonings, site plans, conditional uses, variances, administrative adjustments, plats, special exceptions, licenses, and permits. The key elements: finding of facts regarding the specific proposal, exercise of judgment and discretion in applying adopted policies to the specific situation. The process is you provide the notice to the owner and the affected persons or parties. There is sworn testimony, or there should be. I will say right now, I do not know what your body does, but the best practices procedure is to swear in your witnesses. So whether it's the developer presenter or even your own planning staff, you should swear them in, because having testimony under oath matters. Parties have a right to call and examine witnesses. So if I'm the applicant as a party and your staff speaks first, which would be typical, and then I get to present my information, I would also get to call my planner. I'm sure you've seen that, or my architect, or my engineer, or my parking guy, or my traffic guy, or whatever, to make the case that I meet whatever your code says I have to meet. Effective
Cliff. Over here.
Oh, okay, yes.
One clarification. The parties are the city, the applicant, and affected parties.
And affected
That means
parties.
the people in the audience would be affected parties.
Not necessarily. And we're going to get to what makes an affected party. But not all parties who are citizens are affected parties, and that's different. And the best way I can explain it is, I love the fact that I have a visual aid. Right now, he's not an affected party because I'm far enough away. As I get closer without my mask, he becomes an affected party by the fact I'm not wearing a mask. It works the same in this arena. So the property owners directly associated with, on either side around the project, those are affected parties. And to not recognize them as affected parties and allow them the rights I'm about to tell you that they have is also a basis for you to get sued and lose on the basis of violating their due process rights. Because much like in a criminal case, you have a state attorney and a public defender, somebody who's prosecuting the case and someone who's defending the case. In this regard, the prosecution of the case is frequently the staff and the applicant, and the defenders saying, no, the case doesn't work for us, are the public defenders. And those are the people who have an actual interest, more than just a general interest, in the outcome of the matter because of their proximity to the project. Okay?
So I got a question on that.
Yes, ma'am.
So if we have affected parties that, on a quasi-judicial, now I'm assuming this is only quasi-judicial, their properties are adjacent, does that mean we do not have the right to put them on a timer, or they have as much of a right to speak as the developer does?
No, it's a good point to make because you got two categories of participation in a quasi-judicial hearing.
Right.
One is the participation by affected parties, and no, that does not mean you can't put them a time limit, but it does mean they have additional rights to the general public. So if I'm the non-affected party, I'm far enough away from the situation, I get my 3 minutes or whatever you provide, and I say, I'm against this project, here's my special expertise and why I should think that this thing shouldn't go and what criterion it doesn't meet, and then I sit down. What I cannot do as a member of the general public, I can't cross-examine the developer or the applicant. I can't cross-examine the staff. I can't bring my own witnesses. I can't present my own reports, at least in terms of them being evidence in the way I would have a right to. Typically, they can be presented as public records, and you can consider them if they qualify as competent substantial evidence. But I wouldn't have a right to question the evidence presented from the podium by the developer, the applicant, the witnesses, and so forth. But as an affected party, I have all of those rights. And you need to allow for those in order to have an effective quasi-judicial proceeding. So if I'm the neighbor who says this is wrong and here's why, it's different when I tell you it affects my property value than somebody who lives a mile away. And so when I say it affects my property value and here's my appraisal and I want to cross-examine their guy, I got to be able to do that.
Yeah.
Question?
All right.
I heard two. Yes, sir.
You're talking about affected parties
Yes.
and being directly affected, but, you know, as an example, Keystone Pipeline just got shut down.
Right.
X number of people are laid off by that company directly, but the companies that have contracts with piping, concrete, other things are technically under, you look at it as butterfly effect, they are affected.
Yeah.
And when they still have those same rights.
No. But again, that doesn't mean nobody has those rights. So it's hard to use your example and try to figure out where to draw the concentric circle of these people in, get cross-examination, and these people out don't.
Well, you use the example of property values. You create a excess of available properties there suddenly by putting 500 homes online, you are affecting the property
Yeah.
value of somebody pretty much anywhere in the city because you've created this extra surplus of property.
And that is why the courts have carved out a special definition for what makes an affected party. But when I get to it, you're not going to say, oh, eureka, I get it. Because just like trying to explain where the circle is drawn, it's going to be a judgment call. And what I'm going to suggest to the members here, including yourself, is you should err on the side of granting it as opposed to not granting it. If you don't grant affected party to someone who clearly will qualify, that's a mistake that could get you sued and lose. Whereas if you grant affected party to somebody who probably isn't, or it's kind of borderline, then your better choice is to let them go. I mean, so in other words, if it's a close call, I would grant affected party status. If I'm sitting in your city attorney's chair, that's what I'm going to ask you to do. But if you say, well, everybody's affected party under your logic, then everybody in the city gets to talk about everything and provide, and it becomes chaos. And this has specifically been recognized in a case, Caroline versus, I can't remember, by one of the other lawyers that Ms. George would probably know, Siegel George would know, Brent Spain, who was advocating on behalf of the, as it turns out now, non-affected parties that they were allowed to examine because they were essentially people with rights, and the court said, nah, that's not going to get it. And so at the end of the day, that's the difference. And so even though you may be further outside the circle, the people who are inside the circle do get to do all of those things and essentially represent your interests at the same time. That's the way it works.
I was very kind of like when they say applicant and people opposing parties or affected parties.
Mm-hmm.
Could the city or board get in trouble if they let like a developer talk for a half hour? Or you let the affected person talk for 2 minutes?
Well, again, that's where you have to have some rules and also be flexible upon the advice of your attorney as to what is fair and what isn't, but let me explain how that works. It is very typical for the applicant, developer, property owner to get more time to present their case. Why? Because they have the burden of proof. We haven't gotten that far in the discussion yet. But since they have to prove the case, they have to be given a lot of leeway to prove the case. If they have to meet, for example, on a variance, which we'll get to in a minute, all 5 elements by competent substantial evidence, it's not the same as saying, please approve our project. They got to put on the person who says, this is the reason I am required, I'm entitled to the variance, this is how I meet the standards, here's my experts that testify to it, so I can't do that in 5 minutes. However, as an affected party, I don't need all 30 minutes. So whether I should maybe get 10 or 15 and have some flexibility in there, if the person says, listen, we generally grant 10 minutes to affected parties to do their thing. If we see like, you're making progress or there's something valuable here, we might liberally grant additional time to continue if you're in the middle of discussing an issue with a witness. But those things are judgment calls, and so they're not things that I can give you a defined answer. It's sort of the old, you know it when you see it. If it seems unfair, it probably is. If it seems like the person is just talking in circles and you don't want to turn them down, you probably can. And so that's kind of the way you would judge it. And I don't know who was first, so yes, ma'am.
So,
You're Miss Northey, yes? Okay.
so I'm trying to work this one through.
Yes.
Can I stop you for a second, Pat? Can you guys use your microphone, please? Because
Okay.
this is
All
live
right.
and being recorded.
Okay, can you hear me?
Yeah.
Okay, so in trying to, the fairness element, that's what I'm referring to. Don't generally, and I understand that they have to have the evidence, they submit the evidence, but there's usually reports in your agenda package.
Yes, and those are from staff typically.
Okay, but staff has reviewed those reports, provided them. Does that not act as evidence that would not require the person who wrote the report to appear or to stand up there and take up time?
It's a great question, and the answer is sometimes. And so, and let me explain why that's true. You know why? I know why people hate lawyers, because the answer's like that. But let me explain why, okay? So again, it's in the presentation. I hate to do this because I don't want to be one of those people who say, just wait till I get there, because really it's in there. But to cut to the chase, anything your staff presents you because of their credentials is considered evidence that you can rely on. So
Right.
if your staff says this thing meets all the criterion, and assuming your staff is competent and they can't be undermined in some fashion, that's what the cross-examination is about, then in theory, all applicants and developers could say, we're relying on staff and we got nothing else to say. However, they run the risk when they do that of they have better experts, maybe better reports, maybe better testimony, and if the folks who actually make the decision are less convinced by staff than they might otherwise be, which shockingly happens more often than you might think, and they just throw the staff right under the bus, then the developer is hardly going to be comfortable sitting there thinking, boy, I really wish I hadn't relied on staff. I should have presented my own case. And so can they? Yes, because technically, by law, if the staff says, we think this application meets all the requirements, without taking into account the public input, which I know you guys probably don't care about, kidding, or you care about, which, kidding, then yeah, we didn't even hear from the staff. They meet their requirements, let's vote. But that's not how it goes. So the answer to your question is they can do it. It does qualify as competent substantial evidence. What frequently happens is the staff says, well, they meet these 3, but they don't meet these 2. Or they meet these 4, but they don't meet this 1. And that's where the then debate becomes, at least legally, significant as to whether the staff is right, or the developers, experts are right, or the public is right.
But the affected party
Yes.
also can bring evidence forward
100%.
of just like the developer did.
Absolutely.
So-
And not only can, but if they actually want to win,
They should.
should.
They should, right.
Because opinions in this realm, unless they're experts,
Right.
do not matter, and I know that's going to make your folks crazy. I don't care if you bring me a stack of 500 petitions that say I hate it, that's not evidence, and we're going to get into why, okay?
So can I ask a quick question?
Yes, sir.
Like, usually our developers, when they come, they bring their presentations, they get to use the board, and they do their presentations. An affected party, would they be, under the law, granted the same means to be able to bring a presentation and put it up on that board?
If you were in my city, yes.
Okay. Something that I think we need to take into consideration, because I don't think we generally allow that.
Yeah.
That's only on quasi-judicial.
On quasi-judicial,
Correct.
right.
Okay.
On quasi-judicial. Whether you do it on other matters, that's a matter of policy, but on quasi-judicial, it's a matter of requirement. Yes, sir.
Is there some standard spiel when somebody comes up and says, I want to testify or speak as to whether they're an affected party?
Yeah, well, I'm getting there. I'm getting there. I'm going to give you what the court has said makes an effective party. How you apply that is going to require assistance of your city attorney or whoever comes to your P&Z boards and sits in on those meetings. But it is as many things that come out of the court as clear as mud, but it's all I got. And I'll try to explain then what I think it means.
Are you, I'm sorry, just as we move along, are you going to be breaking down what a witness actually constitutes, what an expert constitutes? Okay.
Yes, absolutely. So if you look under the bullet point just previous, it says parties. Parties are the city, the applicant, which can be developer, property owner, whatever, an affected person. So those are the people who are parties, and they get additional time to present, to cross-examine, and the other rights that we talked about, opposing witnesses on relevant matter and rebuttal evidence. And the failure to provide, whether it's an affected party or a developer, the opportunity to cross-examine what staff says. For example, if staff says, let's suppose for a moment I'm wearing the developer hat, and the staff says this thing doesn't meet this criteria, and I think the staff is just dead wrong because I got 10 experts who'll say the opposite. I should be able to cross-examine the staff and say, oh, really? Well, where'd you go to school? Where'd you get where do you come to that conclusion? What do you base that on? Did you actually look at this? Do you know about this study? Have you looked at this traffic pattern, et cetera, et cetera, et cetera? To make the point that when you have to choose between the staff's opinion and my expert's opinion, you should choose mine. Do you have to? Absolutely not. You can believe whoever you want to as long as they constitute evidence. One of the key and unique factors to a quasi-judicial proceeding.
So is an affected person has the right to ask to develop the questions? What happens if, like in our meeting, they don't get that right? Can the city be in trouble for not letting the affected persons talk to the developer?
The answer is yes. If you mean by trouble, could it end up in a lawsuit that the city might lose? It's not the only factor.
Refuse to do any interaction at a meeting.
If they're refused the opportunity and if they bring the proper challenges and they have a good lawyer, then the answer is you might lose. So that really does matter. Applicant and affected parties are entitled to more than the 3-minute rule because their rights are uniquely affected. Uniquely affected. In your capacity as the board or hearing an appeal as the commission, you are essentially need to be thinking of yourselves as wearing black robes. And what does that mean? Well, I'll put it in simple terms because most people, particularly those who walk in political realms don't think of themselves as anything other than people who need to be accessible to their constituents and open and transparent and all those things. Depending on, what side of the aisle you're on, you might be transparent on one thing and not on another. But the idea is you rarely think of yourselves as someone who, A, can't have opinions, and B, shouldn't have opinions. Because guess what, guys? Y'all have opinions on everything, which makes you normal. But judges aren't normal, and they're not supposed to be, at least when they're wearing the robe. So what does this mean to you? Well, it means that if you walked into court on a traffic citation and the judge said, I know you, Mayor. I saw this violation. I was there, and you're guilty. I haven't even opened my mouth yet, and I'm guilty because you saw it and you have an opinion. You haven't heard my evidence. You haven't heard any part of my case. Is what I just said, and the mayor would never do this, but is that fair? Well, clearly, we may not be able to get an agreement in this country on a lot of stuff, but I think we can all agree that's not fair. You don't expect your judge to be your witness or your prosecutor. You expect your judge to be the non-biased person who hears the evidence and based on the evidence makes a decision. And the word quasi in front of judicial only implies that the formal rules of evidence as such do not apply, and you don't have to have a law degree to know them. But what you do have to have is a fundamental sense of, when I came in here, whatever I thought doesn't matter. What matters is what I heard when I got in here. Or, in some cases, maybe what I learned before I got in here, if properly disclosed, and we're going to get to that too, okay? So the hearing process. Where evidence conflicts, the board has the responsibility of deciding how much weight to accord each piece of evidence. Let me put that simply for you. Again, using a simple example of a red light runner. 5 witnesses come in and say, I saw the guy run the light. 1 witness comes in, it was absolutely green. The other 4 are liars. Do you have to choose the 4 over the 1? The answer is no. If staff says it doesn't comply and the developer brings 10 that says it does, can you believe the staff? 100% yes. If the affected parties bring 1, the developer has 10, and the staff's on the developer side, can you believe the affected party witness? The answer is yes, as long as it's competent and substantial, and it goes to an element of the case that has to be proven. So on the area of what witnesses you have to believe, what testimony you have to believe, the answer is as long as it constitutes competent, substantial evidence, you can believe whatever you want. That is not the issue. So if you believe that the criterion, 5 criterion that you need, for example, for a variance are not met, because one of them isn't met, because you heard one expert say something that they didn't meet, even though the staff disagrees, you can choose to believe that one expert to deny whatever it is. Similarly, if the staff said, I don't think this meets this element, the developer says it does, the affected parties say it doesn't, you can choose to believe the developer witnesses. This is the way it works. In terms of judgment of the evidence, that's your realm. What is and isn't evidence, we're going to get to, because not everything you hear is evidence. All right, in continued hearings, if there are hearings that sometimes go, I don't know this happens here, but sometimes in my cities they go into the wee hours and you get canceled or say we need to hold this over for the next time, you need to make sure that the same people who were there for the first time are there for the second time, because you can't have judges coming in and out, just like I can't have, in my example with the mayor, I couldn't show up in front of the court as the mayor and expect my decision to be made by a different judge that heard the evidence the first time than hears the evidence the second time. Record keeping is important, keeping all things, exhibits, and things handed to the clerk or shown to the board, because if there's an appeal or a challenge, you'll need those things later, and so will the people making the challenge. Review is on the record. There's no ability to create additional evidence after the decision is made. Yes, ma'am.
I have a question about this. So could you explain a reasonable time component for gathering evidence when it comes to decisions on a large-scale plan like big developments? What is a reasonable time to be asked to gather evidence or for that hearing?
Okay, so the answer really is going to depend a lot on how much authority you give to your staff. Because at the end of the day, hearings are typically scheduled before, whether it's this body or your body, based upon when staff says, we have a compliant application. A compliant application has all the elements that are required by your code, surveys, reports, whatever is necessary, and they shouldn't be putting it on the agenda for any one of you if it's not ready, because it's not a compliant in terms, not that it meets the criterion, but it meets the qualifications of, I got a completed application. And frequently applications are rejected because they're not completed. I don't know your planning staff, but I'm sure if they're here somewhere, they might be nodding, that's true, because that's the way it works. So by the time it gets on your agenda or on the P&Z agenda, in theory, something is ready to be decided, not that it's proven one way or the other, but all the material needed to consider whether it's proven is ready to be reviewed. That's the typical way. Now, if the question then becomes, okay, how much time do we give affected parties to get ready? Because at this point, the staff and the applicant should be ready, right? They've got a completed application to go forward. That's the different question, and that's going to be determined by not only what your code says, but maybe how your code should be amended if you think in certain situations additional notice should be given. Now, along the way, if you're an affected party and you're aware that something's happening, and frequently people will tell you, I'm sure you've heard it, we didn't know, but if you are an affected party and you know all of the things that we're talking about, whether it's the application, the attachments to the application, the various other reports that are part of it, they're supposed to be part of the public record and able to be accessible. One way that you can accomplish that for your public is to provide links along with every application in the process with every document that gets filed so the public can download them as they're coming in real time. But in terms of whether or not you might need to say, okay, from the time we have a completed application, it shouldn't go on the next agenda, but if it's a project that has, let's say in residential, it's got more than 500 units, therefore we need to give it 60 days or 45 or whatever. Subject to any statutory requirements, that's a code issue for you to change to your liking, whatever that means. And so I can't answer what reasonable is. In large part, other than making sure it doesn't violate statute, it's up to you to determine if you're talking about affected parties. But as to the staff and as to the applicant, that is already determined because they don't get before you until they're ready. Okay?
Cliff, question on that.
Yes.
You've talked about the application being completed in full. When it comes before the Planning and Zoning Board then, anything that's been agreed on, any variances to that, any part of the plan itself that should be on paper, we shouldn't be getting anything before us that there's been a verbal agreement that the developer is open to a change. If that change has been discussed, it should be in writing then, and that would be considered the final application then, wouldn't it?
Well, it's not that easy to answer, but let me explain. So frequently, even in the course of hearings that you might hold, negotiated conditions happen on the fly. That's not unusual. So,
well, I'm talking about a discussion that's already been had with city staff and with the developer. If that discussion's been had, shouldn't we have that finalized presentation where we can see everything actually agreed to in writing?
In theory, that would be in the staff report. In other words, for example, I don't know what your equivalent here is where you have an actual DRC, Development Review Committee, or a TRC, but typically a DRC, Development Review Committee, is the staff heads, you know, whether it's the police, the fire, the public works, whatever, and they get together, and they also review the things typically before they come to you, and they say, we had a concern about this regarding fire access, or we had a concern about this regarding whether there was going to be sufficient water drainage taken care of here. The developers agreed to revise the plans. We're waiting on the revised plans, but they know this is going to be a comment that we're going to have in our report, and so with that, as long as they make this correction, we're okay. So if by that you mean, do you actually have it, or it doesn't go? No. But it should have already been recorded by virtue of the minutes or the report from the DRC or other staff so that it's memorialized somewhere. In other words, if I come to the meeting of yours and I'm your planner and I say, we've talked about that and it's going to be no problem, my answer, okay, show me. Don't tell me, show me. And we're going to talk about show me in a minute. But show me meaning, where's it in your report? Where's it in your minutes? Where does it say the developer's on board and you have an agreement? Because otherwise it's just words. Now, in reality, is it just words? Depends on the developer or the applicant. But in terms of safety, put it on paper.
Because my concern is, we don't have that in writing. We've talked about, opening up the city to liability at this point. We don't have that in writing. It goes forward from us. Say there's something flawed in a staff report, codes that apply to future land use that might not line up with the definitions. By us even voting on that, aren't we, by pushing it forward to the city commission, opening up the city to lawsuits from the affected, either the applicant or anybody affected within that localized range?
Again, it all depends on, there's so much that's going on in your question, because when things come out of P&Z that the P&Z says, as an example, we think this project is fine, subject to our own comments, which are A, B, and C, what you're telling me should be in those comments, A, B, and C. So now you've done your job. You've put the commission on notice, hey, we thought this was an issue that needs to be resolved before you give final approval to it. But at the end of the day, the decision is these folks. And that's true in every jurisdiction, so that's not new. So as long as you've done your job, which is, it didn't come to us from staff this way, but we are saying it should have A, B, C, D additional things added to it, and with those things added, we'd be okay. Once you've told them, now it's on them. And I'm not pointing fingers, this is how it works, okay?
No, can I just stop you for a quick second?
ma'am.
We do have a DRC process. The DRC process is listed, all the meeting minutes are online, and the decisions and the comments, Mr. Peters, correct me if I'm wrong, are all documented through the DRC process. So when you have, like you said, Mr. Shepherd, an issue with fire, an issue with access, all that is put through a DRC process. And there are always, correct me if I'm wrong, moving parts.
Yes.
In something like that. And if I can just stop you at one more time, I was going to do this at 9:30.
I'm going to defer to Mr. Paradise, but it is a continual process, and the minutes are available. Quite often, you will see that a project is in a bad state, and it works its way up to a point where staff can support it. Mr. Paradise, I don't know if you want to expand on that or not.
Can I just stop you for 1 second? I was going to do this at 9:30. Since we have an extra table up front, are you a member? You're an alternate member, ma'am, correct? Would you like to just come up here? Because I don't believe that Chairman Podkowski is going to be here, so I feel bad for her sitting back there and everything, so
And
I
we
feel we've...
also have a seat over here beside me.
Okay, if someone else, she can come up here if someone else decides is coming in, we can arrange that, but I just wanted to do that. Thank you. I'm sorry.
No problem. So review, let's say something is being appealed. In some cases, you are quasi-judicial sitting in an appellate capacity. Another, in fact, of quasi-judicial is if you were sitting in an appellate capacity as opposed to an original final decision maker. The record is the record that you get when you get it. It is not what they get to add after. So in other words, if there are areas, and I don't know what that might be in your P&Z, and it varies from city to city, where there is final authority subject to an appeal, meaning that if there's no appeal, it never comes to you. Those items, if there is an appeal, let's say this board denies it, the developer applicant does not get to supplement the record on appeal. The rule is that whatever they put on that these folks saw is all that you get to see. The fact that the developer or the applicant or property owner after the fact said, boy, I sure wish I'd have done this, this, and this, too bad. This is where you do it. And if you screwed up, you don't get to fix the screw up for them by saying, well, now you get to put, because now you're them. You're now at the original board with a brand new decision. And that's not fair to these guys, and it's also not fair to the public. At the end of the day, if I go in as an affected party, let's say, and I oppose something because the applicant clearly has missed some step, and as a result, these folks do their job and say, you're denied, and say, well, I left it out. Oh, well. And that's the harsh way the law works. You don't get to make it up as you go along, shape shift your case to fit, oh, well, if I'd only known that, I'd have said this instead of what I said. That's not how it goes. And so important to understand that when you're sitting as an appeal as opposed to the final decision maker, okay?
Mr. Shepherd, you refer to continually in this process of what we're talking about right now, those steps that have to be proven.
Yes.
Are you going to get to explaining that?
Yes.
Because I think that's critical to understanding those steps and what you actually are basing your judgment on and what the P and Z is.
Yes, and I'm going to use as an example because it's the one that's the easiest to get your arms around. There are others, but the easiest one to get your arms around are variances because they're very specific criteria and they're very important that all of them be met. And so we will all be talking about the same thing, and then you can apply the lessons learned there to others. So the board is supposed to give due consideration to the professional judgment of your zoning and planning staff, considering their training and experience, but the question of what code means, what it means, is a question of law for which the board makes its own decision. So if you look at the code and how it is interpreted as to the measurement of height differently, and it's debatable, than staff does, and I use height because that seems to be one that comes up frequently, well, I don't think it should have been measured this way, it should have been measured that way. And if it's not clear, you guys are the final arbiters of how the code should be interpreted. But obviously, unless you all are planners and builders and contractors, you might want to listen hard to what they say and how they got to their conclusion before you decide to go off on your own. But you have the authority if it's unclear. So affected parties are objectors with a standing to sue. If, and this is important, I'll tell you what standing means and how it affects, how it deals with affected parties. Going back to Mr. Bowman's example of, well, everybody's affected in some way. The circle should be huge. Well, yeah, except the courts don't view it that way. A standing is if the project and its impacts affects you in a way that's different and substantial as compared with the other similarly situated citizens, then you're an affected party. And I'm confident that doesn't provide you a lot of confidence in what I just said, because it doesn't me either, but courts know. Because if I can't explain, I specifically is hurt in a way that the guy a mile away isn't, and here's what it is, I get thrown out of court. And if he gets thrown out of court, he's not an affected party, and you shouldn't have said he was. But again, you're better off saying that they are an affected party if it's close call than they're not, okay? So standing to sue is kind of the key element of what makes an affected party. And that depends on being able to show that I am uniquely affected as a citizen or property owner by this thing that you're approving or disapproving in a way that's different than someone who's 100 yards away, a mile away, 5 miles away. We all may have an interest, but interest is not the same as a tangible effect. A person who has a legally recognizable interest which is or will be affected by the action of the zoning authority in question has standing. It may be shared in common with other members of the community, like an entire neighborhood, but not every resident and property owner of a municipality can, as a general rule, claim such an interest. Must be a definite interest exceeding the general interest, that's what we just went through, in community good shared in common with all citizens. We all want what's best for Deltona, but not all of us get to sue about it. The relevant factors include, and these are the things that you were asking about, proximity of property to the property to be zoned or rezoned, the character of the neighborhood, including the existence of common restrictive covenants and setback requirements. One that has been popular in other parts of the state of Florida, not recently, but has made some case law, is cement plants. Nobody likes them. I get it. Who would? But the neighbors who have to live next to the cement plant, nobody wants them, but nobody wants to live next to them. And as between the two, it's the people who have to live next to them who have standing. Okay. Type of change that's being proposed, entitlement to receive notice under the zoning ordinance. So if another way to determine standing is, were these people within the zone where they got special notice of this change? If they were, they're more likely affected parties.
Can I ask
Yes, ma'am.
a question? Because I don't remember. Is that the control, it says what not controlling, but the entitlement to receive notice, is that a standard, or do the cities and the county individually set their owns? I can't remember what.
There is a standard, but you can exceed the standards.
Okay.
So as with many things with state law, you can expand it. We are literally going through this discussion. They're going to have a workshop on it in one of my cities, is Maitland, because much like the question was asked of me, well, when you got a big project, I don't know who asked it. Maybe it was you, sir. I don't know. But if you have a bigger project, maybe we should have more notice. Well, again, as long as you meet the minimum requirements, notifying more people, providing longer time, not an issue. But at the end of the day, there are minimum standards.
There are minimums.
And so whatever the standard are for the one that's in front of you, that's a good way to determine if they got an actual notice, like on a rezoning, then possibly they're affected parties. And I think that's the way I would go.
You just spend a moment,
Sure.
okay, on reasonable proximity, please.
Boy, I wish I could spend every day on reasonable, because I can make a ton of money doing that. The best racket going for lawyers is the word reasonable. And I'm not joking when I tell you this, they tell you this in law school, because who else in the world gets paid $300 and $400 and $500 an hour to fight over what's reasonable? You know, so God only knows. But in terms of what I think, and that's really the best I can do, that it means is, one, in terms of trying to apply some objectivity to it, if you're in the zone of notice, you're in reasonable proximity. Number two is if you can show that regardless of the zoning notice, that you have a specific economic impact that is not going to be shared by others. And those are the two I would rely on as best I could. But again, it is a judgment call, and as I've said, if it's a close call, I would err on the side of saying that the person is an affected party.
Okay, thank you. The next, because these are, and I'm just asking because these come up, these are our main things here that you just talked about,
Yes,
the
ma'am.
relevant factors that we maybe have, you know, need further explanation, right, or clarity on. So I would like character of the neighborhood reasonably defined. And I'm just asking for experience right here so that, because everyone I think needs to kind of be on a standard, right? A same page or in the same area.
That is an area that it is very hard to, in a case before I actually became the city attorney for Maitland, which was more than 20 years ago now, involved scale and character, residential scale and character, which is along the lines of what you're talking about. Is this project of residential scale and character? Does it fit with the character of the neighborhood? And I can tell you the things that get looked at, but it's much like, and it's a coarse example, but the example that we've all heard at one time is that I don't know how to define porn, but I know it when I see it. And so when you look at residential scale and character or the character of the neighborhood, you will hear people with a straight face be able to make an argument on both sides. A case I just won last year involved the city of Neptune Beach and a 500-unit apartment complex that insisted that because it was residential, it was in character and scale with the neighborhood, which was otherwise single-family residential, because all residential is clearly of the same character. But obviously, people disagree about that. Did both sides make the argument that it was? Yes. Who was right? Well, at the end of the day, the council determined that the people who said, no, apartments don't work in a residential neighborhood that is single family, and that was upheld on appeal. But in terms of both sides making the same argument, they both did. And so there's not a real clear way to tell you except your own judgment. And that will differ from one to the other. I have learned, and if we've learned anything on the national scale recently, we can all look at the same set of facts and see them completely differently. And this is true about scale and character as well.
And what is the, just off, you know, in your experience, what is usually, in determining this factor to make sure it doesn't come back on appeal, to make sure that all areas have been explored, to make sure that, you know, you have proper definition or understanding, what is the weight, okay, of character of an area? And if you have 100% factor, right, all factors, and everything being relevant, what would the weight of character of a neighborhood go into a legal decision on in these types of matters?
The weight of that is left to the deciders, you all, or in some cases the P&Z. How much weight it should be given is equal to the others, and the reason is because, for example, in a variance category, you have to prove existence of all five in order to get the variance. And The one thing I will tell you, and some of my cities like it, and some of my cities don't, and some of my applicants like it, and some of them don't, is that it is the one where you have the most discretion because it's the most difficult to put your arms around. It's like trying to grab hold of a slippery eel. And if you've never done that, it's not easy. The analogy we use here in the South is a greased pig, but it's the same kind of thing. So what you have to do, it is, so in other words, to answer your question directly, you could specifically say that my decision is based on this project not meeting the character of the neighborhood, and that's why I'm voting to deny this variance or this project, whatever it is. And you could have a disagreement from this end of the die, Ms. Bradford, for example, saying, well, 100% it does, and here's why. Then there's a vote, and whichever way the vote goes is the answer until the court tells you differently. And most of the time, for reasons we'll discuss, whichever way the council goes on something that's that sort of loosey-goosey, if you will, is what the court's going to do, because courts are reluctant, for lots of reasons, assuming you meet the procedural hurdles, to supplant their own judgment on an issue like that for yours. In other words, in my 36 years of experience of doing this, I've never seen a judge say, these people decided it wasn't within the character and scale of the neighborhood, but I, as a judge who don't live anywhere near there, say, I think it is, and it's approved. That doesn't happen. So whichever way it goes on something like that is probably the way it will stay.
So it is therefore subjective?
Yes.
Based on an individual decision, right?
They are subjective with some things that would be clear. Like an example. Using the residential neighborhood, I think we could all agree, although today in time I'm not sure, but I think we could mostly agree, probably a high 90 percentile, I'll go that far, that an airport in the middle of a residential neighborhood, not consistent. Beyond that, I don't know. You know, maybe a sewage treatment plant, also not consistent. But whether an apartment is or isn't, or a condo is or isn't, different question. Don't know. And so in that case, if you said an airport was fine in the middle of what was clearly just residential homes, and the residents challenged that, they have a decent chance of winning on that issue. But if they challenge the apartment versus no apartment issue, they might not win.
And thank you for that explanation. And if you have a last comment so that we maybe can move on, is there a legal definition of character of a neighborhood? I mean, is there a litmus test for that? Like, taking, I don't know, is there a general definition that?
There are cases that discuss what was decided by a given community, like the Maitland case, and whether the court said there was basis to support that decision, but that's as much as they go. So for example, and I'll use that case because it's one I'm familiar with. There was a proposed significant development, included shopping and various other things, and all the neighbors said this is not residential scale and character, it's too big, it doesn't fit, and all these other things. There was litigation, and the court said, and this is what the courts will say, the city found that it was not of residential scale and character. And that decision was supported by competent, substantial evidence. So they don't ever say you were right or wrong. As long as there was evidence to support the decision you make, they uphold it. So that's the answer, as best the answer you can determine.
No, that's perfect. Thank you very much.
May I ask a question? When you made a comment, and I'm sorry, I don't know which bullet point it was under, but you said if someone is an affected party, obviously if you're within the notice of the zoning change, for example, on land use, you'll get a notice. The other thing that you mentioned was economic impact. Like if you're not in that zone, but you maybe feel like you're being impacted economically, do you have an example of that?
Well, I don't have a specific example, but I can use something that I've already alluded to because there are several cases that deal with cement plants. Everybody who lives in a community, a small community, not something like New York City, but in a smaller community, thinks that cement plants are a bad idea, even if I live on the other side of town, of a small town. So they would tell you that I don't want to be the town that has a cement plant, just like I don't want to be the town that has the toxic waste dump, or I don't want to be the town that has whatever. And I live on the other side of town. I may never smell it. I may never even have to drive by it, but I'm affected. So somebody is going to say that, and they're even going to say, I think overall it will lower my property values. Or if it doesn't lower them, it will keep them from going up as fast. Because if I have a choice between in community A, toxic waste dump, community B, no toxic waste dump, I'm going to community B. But that's not the same as standing. And so that's an example that I can come up with off the top of my head that I hope makes the point. If it doesn't, I'll try another one.
Yeah, I'm still a little bit, because when you talk about having someone be an affected party that's going to state they are an affected party due to economic impact.
You have to pull up, procedurally, you need to pull that out of them a little bit. What do you have? Do you have an appraisal that shows if thing is proved how you're going to be affected in a way? And typically, as you probably already know, the answer is no, because appraisals cost money. Well, do you have an opinion from a local realtor that says your property values are going to specifically be affected, and how much based on home sales in the area, based on a history of doing real estate for the last 20 years, as an example? But if all I say is my property's value is going to be affected, that's an opinion unsupported by evidence.
Okay, that's what I want to be clear in, because a lot of times during these things, we have people come in and they say, my property, this subdivision is going in behind my house and this is going to kill my property value.
They say
or
it all
this
the time.
zoning change is coming in, my property value is going down. And if someone's going to claim that as an affected party, I want to know the criteria. And then you're just telling me, do you have an appraisal to state that? Do you have anything else? Because everybody can say that.
The same way everybody can sign a petition, and that's why petitions are not evidence.
But you're talking about allowing an affected party, someone to
Correct.
claim they're an affected party through economic impact, and I'm just trying to be clear on the criteria.
They need to provide evidence of their status, just like an example that you may be familiar with, since you all have seen, I'm sure, more than your share of legal shows. When they put an expert on the stand, what is the first thing they ask them? Well, what are your qualifications? Where'd you go to school? How do you know that? What training do you have on property values? And it may be the property understanding in front of you is, well, I happen to be a realtor. I am an appraiser. I do da-da-da-da-da-da. But short of that, it's just a lay opinion and it has no bearing. Your voters will not want to hear that, but that's a fact.
But that's because that's how, when we have these hearings, which I'm sure we're going to have more in the future, just by the virtue of being in Florida and being a growing city, that is important for the commission and for the P&Z to understand what evidence do you have of
Right.
that, and it's not opinion. And I think that's one thing that we need to be clear on when we're considering things in a quasi-judicial hearing, whether you're for a project or against it. Am I correct?
Right, and there can be, evidence can take on a number of forms. It's not just, for example, using the value issue, appraisers or realtors. It could also be, this exact project was built across town here. Here's a timeline of the values from this project going in and the home values in that area.
Yep.
And that's why I think, that's also evidence. So I can't predict the kind of evidence to be brought forward. But me just saying it does not make it so. If it did, every project that was opposed by 1,000 petitions would get defeated, and that's not the way this works.
So you can say, all right, this went in on this, let's just say this industrial building went in on this side of town, and all the property, people put up their properties for sale and the property value dumped.
Yes.
And if you're going to put that over here, the same thing's going to happen. That's a direct correlation.
That's evidence.
Okay, that's evidence, but
It
somebody
may or may not be true in that situation, but it's evidence.
Okay, thank you.
Okay?
Who's qualified to present that evidence? Is the affected party, if someone believes that they're an affected party, say that their land value is going down, are they qualified then as an affected party or a witness to present where a realtor has given them a sheet of paper or a statement that says that we believe that the property value is going down? Is that therefore considered evidence?
That is evidence, but the weight of the evidence, which we haven't gotten into, is a different matter. So, for example, and you will all know this is an easy question. Can you cross-examine the paper if the realtor's not there? No. So how much weight should that evidence be given? If it's somebody in the community that's been doing it forever and you trust them implicitly because they've been doing it forever and it's somebody you all know, then that's one set of fish. But if it's some name on a paper, and there are people that do that because they get paid $150 to write a letter that says whatever the writer wants them, the person wants them to say, well, it's evidence. But is it evidence that should get a lot of weight? And so weighing the evidence, it's just like in the situation where I said you can believe the one opinion over the 10. Same thing. So whether this evidence is sufficient to convince you they're affected, that's on them. And so yes, they can present it, and then you can judge it just like you judge any other evidence.
Maritza.
Yes, ma'am.
Thank you, Mayor. So I don't even know how to ask this question. Maybe it's an opinion on your side. I've heard many times, you know, the applicant has crossed their T's, dotted their I's. They've met every single qualification that is required to approve something. But I've been told on a personal level, you can deny it. Is that fair to an applicant?
Is it fair is an opinion, but is it legal is absolutely if on any of the things where the developer says we've met the criterion, you have evidence that that's not true. You can believe the other evidence. You don't have to believe the developer's evidence. For the same reason, you don't have to believe the staff's evidence. You can believe the applicant's evidence if they conflict. So if staff says you shouldn't approve this because it doesn't meet this criterion, the developer says, here's my expert that says I do, you can choose who to believe. Same with the affected party. If the staff and the developer are on the same page, but the affected party says that's baloney and here's why, here's my appraisal, here's my planner, here's my this, and here's how you do it, and here's why you're wrong, that's evidence. And if it destroys one of the things that's being presumed by either the applicant or the staff, in your opinion, you can use that to deny whatever it is. So whether it's fair, it's just like when I said before. You have 5 witnesses say he ran the stoplight. You have 1 that say he didn't. Is it fair to believe the one? That's your call. That's, I hate to say it this way, but that's why you get paid the big bucks, which you don't, but you understand the point. Okay, that's the role you assume. That's what a judge does all day long. Yes, sir.
So basically, like, you have an area, we'll just throw it out, all the houses around this one area are all 2 acres, they got horse tree, every house around. Now, right in the middle, there's 10 acres. All of a sudden, they develop a company wants to put, let's see, 10 acres right now, I don't know, what, 100 houses, 50 houses in this 10 acres plot. That changes the neighborhood.
Arguably.
And so that gives the affected parties that live around that 10 acres a lot of argument. And if you're making a decision.
It gives a right to argue.
Okay, it gives a right. But if, when everything's presented as board members, you can take the affected members and make your decision on their part.
If they present evidence.
That it's affecting their livelihood, their homes, their property. Like I said, everything's like 2 acre land, or you got 5 acres. And everybody around is 5 acres. And then you're going to change this one.
I can't say this strongly enough because I see it, I have been sitting as an city attorney chair for a very long time. There are times when I literally want to scream because I feel for applicants that have no idea of the process. I also feel irritated when the people who actually run the process don't understand the process either. But particularly applicants, because everything you just said is what I hear from everybody who's opposed. But what I don't hear is evidence. I hear opinions. I'm going to be affected. It's always been this way. I wouldn't have moved here except for I came here because it was this way. I always wanted my horses. I never thought I was going to be, and you shouldn't change this on me. But what I don't hear is, where's your appraiser? Where's your planner? Where are your experts that can say this is not consistent according to the rules of the game? To her point, the developer is playing by the rules of the game. Check, 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 check. And he can stand on that, or she can stand on that, or it can stand on that. I played by the rules of the game. You coming in saying, I don't like it, that's not the rules of the game. It's your opinion. You may be right not to like it. That's not the point. And so applicants understand this, and they play the game. People who oppose applicants rarely do, because it's funny how, understandably so, but the rubber meets the road when they actually have to write a check, because experts have to be paid for. So they think, always wrongly, although sometimes they will succeed because of popular opinion, and maybe there won't be a lawsuit. But the reality is, when a person comes here as a citizen who is an affected party, but just brings their own personal opinion, that is zero evidence, zero on which to deny whatever it is. So there got to be something else. I'm asked and put in the position, there was a project in Maitland about 5 years ago where the staff said it meets the criteria, the developer said it meets the criteria, and nobody spoke against it, but the council hated it. So, Mr. Attorney, you're telling me we have to grant it. No, I'm not telling you anything. I'm telling you, what evidence did you hear that said it didn't meet the criteria? Because I didn't hear any, but if you heard it, then deny away. You can't manufacture evidence, and you can't be the evidence. What do I mean by that? This is a point that I was going to make later, and we'll get to it, and I'll then go by it fast. But frequently, we have members of boards like yours and yours who are in their own right experts, planners, surveyors, property appraisers, realtors, who know in and of themselves that something is going to have an effect. And you know where that knowledge has to stay when they walk into the chambers as quasi-judicial decision makers? Outside. You can't be the evidence. It has to be provided to you, and if it's not, then yes, your hands are tied, but not by me, because no one presented you with anything contrary.
So, question, and I'm sorry for getting off. I'm assuming that the affected individuals are under the same requirement as a developer or the land use. So if
Yes.
it was not presented to P&Z at that, the evidence wasn't presented at the same time it went through P&Z, are they allowed to change? Because you said a minute ago that, hey, if it wasn't presented to P&Z, it's not allowed to be like, oh, we can add it. So does that work the same for affected individuals?
It does if, and remember the caveat, because I don't want you to paint with too broad a brush, if what's coming to you is an appeal, as opposed to something with original de novo jurisdiction.
So it's not an appeal, it's just, it's gone to P&Z?
Then they can all
And it
change
comes to
their
the
games.
commission, so can
100%
they
they can
add
change
to it at that point?
If it's not an appeal,
Only if it's
that's
appeal,
only
okay.
if it's an appeal.
Okay, thank you.
Okay. Yes, sir.
We get cases,
Can you use your mic, please?
somebody's got a rural area. They want to build.
I can't hear you even. I'm saying, I got it.
Put your mic closer to
We
you.
got a case, it's a rural area. Somebody wants to do a concentrated development in the middle of that area. And one of the questions for us is, what's the future impact of this on schools, on cost, on traffic, on whatever? Sure. And the evidence that's presented is very unclear. You know, this is what's bothering me. The developer comes in and says, well, there's a negotiation with the state, and they're going to pay for the improvement of the road, but it's not granted yet. So we're sitting approving a development that has future cost, future impact, but the reasoning on that is very unclear and unsound.
Okay. I will do the best I can because, not surprisingly, you're covering more territory than perhaps you can appreciate. First, the question is, it's a complicated case and there's complicated evidence and conflicting evidence. Welcome to the world of a judge. If you think it's always clear who killed who, or who robbed who, or who stole what, just go down to the courthouse and you tell me at the end of the day who did what, because you'll find that it's much easier, and you're no different. And so conflicting evidence is constant. It will, whether your staff says it meets the criterion and the developer says it doesn't, whether the developer says it doesn't meet the criterion, but will be able to meet the criterion if I do this thing, and so between your board and the commission, they will provide that thing. All of those things are part of the milieu, if you will, of making a decision when you're wearing a quasi-judicial hat. But at the end of the day, the judgment of the evidence relies to you. So on your example, when you said, well, they're saying it'll be okay when we get this road that's going to be put in by the state and paid for, if a criteria to do whatever it is they're asking to do is they have to meet it first, then it would be completely legit to say, you don't meet it now and you're denied. It also might be, depending on the code, completely legit to say, based on the information and investigation that we've done, that's going to happen, but no permit will be issued until it does. So there are ways to negotiate the circumstances depending on what circumstance it is. I just used your example as one you threw out. So it's not always crystal clear. That's true in many cases. Sometimes it's crystal clear. If the height restriction is 35 feet and they want to build 60, that's pretty simple. Unless you change it, it's a no, or it should be. But others are more complicated depending on the circumstances.
I mean, it bothers me that we have a plan of development, but the plan of development is essentially unfunded. You know, this area 30 years from now is going to have 6 times the population, and it's do this, but there's a lot of other things that have to happen in order for that to come true. And we, as planning and zoning, may take that very seriously, and the commission may not, because we're working in different viewpoints or something.
Sure, and that's not uncommon. Here's the reality. Part of what you're talking about is just the natural tension, not unique to Deltona, that exists between a P&Z and a commission. Elected officials, appointed. Elected, appointed. Accountable to voters, not accountable to voters. Got it? And so these tensions are normal and natural. In terms of how they are seen in the grand scheme of things, depends on things like an overall plan, particularly the comprehensive plan, and whether that needs to be changed, something you all debated last week. In terms of the issue that you're specifically saying about things are not specifically in place right now for this development, and if that is a criteria that must be met to go forward, then your opinion should be, can't, because it doesn't meet here, the box is not checked. And you then say no, and depending on the circumstances, there is either an appeal or there is, you're just advisory and it goes for final decision to the commission most of the time. And when that happens, then they get to look at the evidence the same way you did, but they may see it differently. Okay.
Does it ever cause big issues when planning and zoning board and the commission totally disagree?
Yeah, it does.
I mean, does that cause big issues for the city overall?
No, well, it can, but usually when things get out of control, you'll find people disappearing off the P&Z. So, I mean, that's just a reality. I'm sure Ms. Northey kind of knows what I'm talking about. At the end of the day, you know, this is not an attack on anybody on either side of this debate, but I've seen it play out. And as elected officials, they want your best effort, but that doesn't mean they have to bow to it. And they were elected to do their jobs, which means to make decisions. And if you don't agree with those decisions consistently enough, then they find you on the opponent side of the next election. That's the system. And so it can cause a problem, but the problem that it causes is when one side or the other is doing something that violates the law. A good example in a case that I was involved in, we had a P&Z that was, or planning board that was responsible, as you are, for looking at comp plan amendments before they ever come to the council. They mistakenly thought, because they hadn't had the training that I'm giving you, that as soon as they put the comp plan amendment that they thought was good in front of the council, they were done. And as a result, they started emailing each other back and forth about what they had just done and how great it was, and we wait to see what council does now. You already understand the problem that's coming? Because the council got it and said, this is crap, no, excuse my French, and they want to send it back. But once we see the emails going back and forth, we can't send it back. Why? Because you guys, not you personally, but that board has violated sunshine, and to send it back now makes the whole thing vulnerable. So they have to then, which is what happened in the Ponce case, which you know about, take away the LPA designation that you currently enjoy and bring it back to themselves because there was nowhere to send it. So those things do happen, but they're rare, thankfully.
Commissioner King had a question.
Yes, sir.
First, I'd like to make a statement, and then say something about it. Sounds like to me, when we talk about affected parties, that they are at a disadvantage.
Most of the time, that is 100% true. Primarily because they don't understand what I'm telling you now.
They don't know the process.
That's right.
They don't know that they have to have evidence.
That's 100% true.
And so I say to our general public, what I think should happen in the general public is they should start some kind of a 501c organization that could help individuals, affected parties, come before this commission or the P&Z and lay a case. And our citizens don't have that right now.
The first thing is education, sir. And again, there's a lot to cover here, and I want to cover that specific point, though, because it's something I'm fairly passionate about, you probably can tell.
Okay.
Because I literally sit a lot screaming in my head,
Yeah.
which means I probably ought to be committed. But I'm screaming in my head, where's your evidence? And the reason is they don't know what they don't know. I use the Neptune Beach case as an example, not only because I won it, which makes me very happy, but also because it was an example of how it's supposed to go.
Right.
The citizens were opposed to this project called Atlantic 500 or something, which was this big apartment complex. It was not just an apartment complex, but that was the big feature that caused people frustration. It was going to replace an old shut-down Kmart. And the issue for the citizens before this particular person got involved was that they opposed it because they didn't want apartments. They thought the traffic would be terrible. It would increase overnight the population of Neptune Beach by like 10% if it was fully occupied. So there were all kinds of issues. But if you checked off the staff's view, is that it met the criterion to be approved. Thankfully, a human being reached out and got advice and then started a group, I forget what it was called, Neptune something, Neptune Strong. Everything's strong. You notice that? So it's Neptune Strong. And Neptune Strong was run by a couple of folks, I'll spare their names. But they started to consult, which is the first thing, is with a lawyer. Not me, but with a lawyer who explained to them what I just got through explaining to you, which is you can't just go up and say, I don't like it. You got to show them why. They hired an appraiser. They hired a realtor. They hired a planner. I think in one case, they got the services for free because he or she was affected by the community. So that when it got to me, I was ultimately brought in to represent the city. The city, hearing the evidence against the developer and one of the higher powered lawyers up in the Jacksonville area, took an appeal from the decision, said, no, we met all the criteria and you had no choice, you should have granted it. But I was able to go through the record and point to the evidence presented by the citizens as affected parties that clearly showed that a couple of the, in that case, it was like 7 or 8 elements that it had to meet, not 5, like yours. And it didn't meet them, and here was the evidence to show it. And even if you believe there was evidence on both sides, you have to uphold the decision. On review, the court agreed, upheld the decision. They took it to the First District Court of Appeals that also upheld the decision. That's how it works. But it starts and it ends with evidence.
I have a question now. It seems to me that sometimes evidence isn't available until after the fact. A guy says, my business is going to be affected by this development. He can go out and get a realtor and say, yes, when they develop this property, you know, your property value is going to go down. It's not going to be what it was. He says, my business, which I'm a business owner, my business is on this property, and my business is going to be affected. It's hard to prove that. I mean, he can get his accountant to come in and say, well, you know, this is his economic state at the time. But anything that they say it's going to be affected in a negative way in the future if this development happens is projection. It's hearsay. It's not evidence.
Well, I would differ with you in this regard. You said he could get his accountant to say, as soon as you put the word accountant in front of him, that's evidence, because he's an expert, or he or she is an expert. And so if I, as an accountant who have been doing his books for the last 10 years, say, look, here's what his records show, here's what it's based on, it's, you know, I've consulted with Mr. So-and-so who does traffic, the traffic count is going to be reduced by X hundred cars per day or X thousand cars per day. I can project based on my accounting background that is evidence. Now, how strong an evidence, that's for you to decide, but it's evidence. And so is it difficult to provide evidence? Mostly, it's costly, meaning it's not free.
Right.
That doesn't mean it always costs a ton of money. It just means that and that's for most folks, they're mad right until the point where they have to reach for their wallet. And sometimes, that's the best way to judge how mad they actually are. When they're reaching for their wallet, they're real mad. But when they're not, they're mad because it doesn't cost them anything. And I'm not saying it should. I'm not saying this is the way the system should work. I am telling you legally this is how it does work.
Shouldn't we be concerned, though, whether the expert is qualified to testify?
100%.
I'd be concerned about the accountant making projections on the loss of business.
That's why he would be subject to cross-examination.
Okay. So to me, he would be worthless.
Well,
if I heard an
and you might view him that way.
To talk about the projection of loss of business.
And that's how you weigh the evidence. Again, so you'd say, okay, it qualifies as evidence, but I don't think it's very important evidence because I didn't think this person was qualified, or when I asked for what was the basis of the opinions, I wasn't satisfied with the answers. They didn't tell me that, oh, by the way, they'd been to Oxford and studied this for the last 5 years and have done umpteen business valuations before and after conditions, et cetera, et cetera, et cetera. And therefore, I'm not going to give that any weight. It still comes in, but you just say, I don't like it.
Okay, so it goes to the question of the weight of the evidence.
The weight of the evidence as opposed to whether it can be admitted. Yes, that's correct.
But we have to remember that the weight of the evidence is equal across the board.
Until y'all weigh it. Y'all weigh it. And then a motion is made. And y'all weigh it. And then a motion is made. And then you know that the other people will weigh it the same way if you win the vote. And if you don't, then they weren't. You saw it one way, they saw it another. I really do not want to start World War III here, but without anybody showing hands or where they stand, I would suspect that a fair amount of people in this room think there was election fraud and a fair amount of the people think there wasn't. And if I asked either to prove it, nobody could. Why? Because they don't have evidence yet. So again, that's the process. Evidence is the key.
Did you want to take a few-minute break? It's 10:30. Does anyone want to take a break or
That is
continue?
completely fine with me. It's up to you.
You guys okay with the 10 minutes, 5 minutes?
5 is good.
5? Okay. Ruben?
Maitland, Ponson, Dean Sprague, he was the first city manager when I was there. He replaced Phil.
questions. Commissioners and board members, please write your questions down so that Mr. Shepherd can get through. And also, what seems to be happening here is a discussion is slowly leading to something that has appeared before us and is going to in a future situation, and that's just getting a little too specific. So we need to keep the questions in the direction for Mr. Shepherd to a general commentary and not something specific that may be appearing before our boards. Okay?
All right. Is it, go ahead. Now it's on, okay. So I will say this is the record I've spent on one bullet point on one slide from the last go-round. The burden is on the applicant, as we know, for a rezoning, a special exception, conditional use permit, variance, site plan approval, et cetera, to demonstrate that the application complies with the requirements of the applicable ordinance and that the use sought is consistent with the applicable comprehensive plan. Now, I told you I was going to talk about comp plan, and I'm sure it's going to come up again, as will other things, because we've had such wide-ranging questions that many of the points that are now in the slide presentation in the future, you go, we already kind of covered that. So I'll go more quickly by those unless there are reasons to slow down. But one of the things I want to explain to you for the purposes of making sure everybody understands this, is that the comp plan is the constitution of land use for your community. And what that means, in plain and simple English, is that you can have something that is varied from your zoning by proper process and so forth, but you can't have a project that is inconsistent with the existing comp plan. Unless the comp plan is amended to make it consistent, it is an illegal project, and the remedy in Florida, and has been for a very long time, is they tear down the project. I am not joking. That actually happened. It will happen again. So consistency with your comp plan for every project you review is the most important thing that you will do, at least from a standpoint of avoiding a bulldozer. Every developer should know it, and you all should know it. So that's important. It's not close. If you have zoning that's inconsistent with the comp plan wins. So everything done and every development, no matter what it is, has to be consistent with the comp plan, and that's why you have the most authority in the area of what your comp plan says. All right, so after the proof has been provided, whether it's by staff, by the applicant, some combination of the staff and the applicant, the burden then shifts, if you're opposed to it, to the government to say that the evidence hasn't been met. So if there's a disagreement between the applicant and staff, and all you've heard so far is everything that's consistent, and you think it's inconsistent, that's the appropriate time to say, well, I don't agree with this staff. What is your position? It should already be in their reports, but sometimes it's not. And when it is, that's when you have to get to the bottom of it right then and there, because there's not tomorrow, it's now. And so it has to be competent, substantial evidence, which, coming from staff, almost everything that they say, if it's related to the project, would be by training and credentials and by case law. But that's the situation. And that maintaining the status quo on the property accomplishes, if they were to oppose to the rezoning, for example, a legitimate public purpose is not arbitrary, discriminatory, or unreasonable. Now, again, most of the ways this works is the staff presents and says, here's our report, you have been provided in advance, we think it meets these criterion, except this one, or we think it meets all the criterion, or we think it meets none of the criterion, or some combination. Then the applicant speaks. If the applicant and the staff are on the same page, then it's up to whatever affected parties to provide you with contrary evidence. You can't bring your own, we've discussed. Quasi-judicial decisions are based on facts, and they do not set precedents. I hear this all the time. It is literally, to me, like fingernails on a chalkboard, because mostly, and I'm just going to point fingers here without pointing to you all because I don't know you all, but it's mostly from my elected officials who say, well, that's going to set a precedent. What they mean when they say that, and what you mean when you say it, is a political precedent, because legally, it is no precedent. It's fact-specific. So politically, maybe. I can't argue that. I'm out of the political realm. I do not miss it. What I am telling you is, in the legal realm, it's of no moment. Each project has to stand on its own merits. Okay, a variance may be granted by the P&Z. We're going to talk about variances only because they have very specific criterion that are easy to look at and determine, where some things are more, what's the word I think I used, a great phrase, loosey-goosey, than others. And so the application of the developer has to have certain criterion that your staff determines before they accept it. The petition for example, a variance has to meet all, and I had thought I put this in here, somehow it may have gotten, I think this is the reason why there's this extra thing over here. I think the slide that was supposed to be here got deleted. But here, I'm reading from your code. It has to demonstrate these 5 things by competent substantial evidence. First, special conditions and circumstances exist which are peculiar to the land, structure, sign, or building involved, and which are not applicable to other lands, structures, signs, or buildings in the same zoning classification. That's the first criterion. And they have to meet that in their application, by their petition, and by their testimony through experts, or themselves if they're qualified to be experts, by competent substantial evidence. The second, the special conditions and circumstances do not result from the actions of the applicant. They can't have done anything to put themselves in the position that they're now requiring a variance from. The third, literal interpretation of the provisions of this chapter would deprive the applicant of rights commonly enjoyed by other properties in the same zoning classifications under the terms of the chapter and would work an unnecessary and undue hardship on the applicant. That word hardship becomes very important because it's not very likely what you think it is. And it's why almost all, hear me here, almost all variances should be denied. Number 4, the variance granted is the minimum variance that will make possible the reasonable use of the land, building, structure, or sign. The grant of the variance will be in harmony with the general intent and purpose of this chapter and the City of Deltona Comprehensive Plan as it may be amended from time to time, and that such variance will not be injurious to the area involved. So you can see when you listen to those 5, all of which have to be met by competent substantial evidence, some have more wiggle room than others. And that's important. So why did I pick variances to be the kind of focus of this presentation? Well, 1, they were one of the most common things that you would both end up dealing with in some fashion. And 2, because they almost always have very clear criterion that are easy to point to, where other things, like whether a PUD zoning should be approved, may or may not have those same clear criterion, or have different criterion. And universally, almost universally, if there's a place that is an exception, I don't know it, they require all of them to be met. Not 4 out of 5, not 3 out of 5. In some cases, it's 7 out, like I think Ponce is like 7 or 8 out of 8. So you have actually fewer than other communities. But the one thing the communities have in common is whatever those are, the applicant is supposed to meet them, all of them. So as it says here, a variance is appropriate to modify the height only, the height, area, size, open space, or distance separation requirements of the chapter, to separate lots required to be combined under section, and this is your code, 110-600A of the chapter, or to construct substandard lots as defined by the chapter. If it falls outside of those boundaries, you're not even talking about a variance. Under no circumstances shall the commission grant a variance to permit or expand a use, not generally or by conditional use permitted in its zoning classification, nor grant a variance for the number of signs or change in permitted signs on a premise. No variance shall be granted which is not consistent with the comprehensive plan that is in effect at the time the variance is granted, not what it may be in the future, but at the time it's requested. And a variance, and as I just said, and your code is consistent with everyone else I know of, a variance may only be granted if the applicant meets all of the criterion listed in 110-1103A, and that's the section I just read to you as here are the criteria. You cannot vary. You don't have the authority to vary state and federal legal requirements. That makes sense, but believe me, I have to tell people that from time to time. They just don't think, they think they can do whatever, and that's not the way this works. So what are the standards? Hardship means the exceptional hardship associated with the land that would result from a failure to grant the requested variance. I don't know anybody who understands what that means, but I'm about to tell you what it does not mean. It must be exceptional, unusual, or peculiar to the property involved. I literally had a debate with a councilman in Ponce Inlet about what the word peculiar means. He thinks it means one of one, which I think it means one of a very few, and I don't know who's right. He may be right, I may be right. Y'all can have your own opinion. Mere economic or financial hardship alone is not exceptional. This is where people get wrapped around the axle. Applicant says, it's going to cost me more money. Your answer? I don't care. Or it should be, legally. Inconvenience, aesthetic conditions, physical handicaps, personal preferences, or the disapproval of one's neighbors likewise cannot, and as a rule, qualify as exceptional hardship, even if the alternative is more expensive or requires the property owner to build elsewhere or put the parcel to a different use than originally intended. Variances are not like lunch. You don't just hand them out. They require competent, substantial evidence, and we've spoken about that, but we're going to talk about a little bit more about what that means. Evidence a reasonable mind would accept as adequate to support a conclusion. If I say, I think it's going to rain tomorrow, that is an opinion. If I'm a meteorologist who says that based on cloud conditions, the barometric pressure, and 10 years of study and 5 certifications, it's going to rain tomorrow, that's evidence. There's a difference. We may both be right, but only one of those opinions is evidence. Substantial competent evidence from lay witnesses, residents, must be fact-based, not opinion-based. What does that mean? I come to the podium. Let's suppose I'm not an affected party by qualification, but I do have expertise. I'm an appraiser, I'm a realtor, I'm a whatever. So long as I lay the basis for my opinion that is fact-based and my experience on the record, you can accept the evidence that comes from a non-affected party. Because again, the key is it evidence? And that's the key to making the decision one way or the other. What you cannot say is, they brought in 500 petitions, and that's the evidence, because petitions are not evidence. They're a waste of time, except they make people feel good. They don't solve anything. Subjective preferences, I love it, I hate it, are not fact-based and do not constitute competent, substantial evidence. Conjecture or assumptions, property values will go up, property values will go down. This will create terrible traffic problems. I think my kid will get killed crossing the street. Those are subjective opinions and assumptions unless they are backed up by evidence. Is it natural to feel compelled to listen to them? Of course. Does it matter in your decision-making process? Perhaps subconsciously. Should it? No. We've discussed the harm to property values and how that goes and what you have to do to show it versus talk about it. Is there testimony from an appraiser about impacts of a similar project? Is a similar project truly similar if they say there is? Does the evidence in the record reflect reduced values, or are you just relying on personal knowledge? Don't just tell. This is, if I could talk to affected parties and members of the community at large in general, I would say this. Telling is not showing. Showing is showing. Show me the evidence. What may be obvious to local citizens will not be known by a reviewing court. You have to look at it in the perspective of, now you're actually a judge. This decision is reviewed by someone who's not from here, probably over in Volusia County somewhere over there in Daytona. Maybe that, as we used to call the 5th DCA, the sages on the Halifax. The people are smarter than everybody else in the room. They don't know. They don't live here, and so they go, I don't know. They say it will, but what is the evidence? And they're looking, where's the appraisal? Where's the opinion? What can I rely on to say they got it right? And all they got to do is find one, but they have to find it. Can't be made up. Property owners testifying from personal knowledge of appraisals, sales prices, or canceled contracts resulting from center development or from pending application should be supported with the documents themselves. So I come to the court. I know for a fact, as a realtor in this community, that when I was trying to sell this house over in that community, this project was proposed over there, and I had to cancel 5 contracts. Show me. Show me the contracts. Don't tell me. Show me. Findings of fact. The Supreme Court has ruled in this state that local government is not required to make findings of fact to support its decision on an application for rezoning. Don't listen to them. Here's why. If you have written findings of fact, it is a good idea in case of an appeal to support the government's quasi-judicial decisions because they are essential to effective, strict judicial scrutiny of quasi-judicial decisions. So if you are trying to direct the court to, this is why we said it didn't meet this particular of the 5 things it needed to meet, here's what we were looking at, they don't have to go looking through hours and hours of transcripts and testimony and so forth. They can look at that. Yep, that's evidence. If they believe that, they win. End of discussion. It's literally for them that simple. Not saying it means they have to look at it all. Sometimes if you're on the side opposing the position that you took, looking at it all is a great thing because who knows what they'll find and what rabbit holes they'll go down. But if you can point them directly, pinpoint, this is what we saw and this is why we decided, even if it's only a majority of you versus the full body, that should be a part, in my opinion, as a best practice of what you should do. They greatly reduce the possibility of arbitrary or politically motivated rezoning decisions and thereby provide protection for property rights by making those findings. They ensure mindfulness of consistency with the comp plan requirement. If local government makes written findings of fact to support their consistency relationship between proposed rezoning and goals, objectives, and policies of the comp plan. Okay, we're going to talk about ex-parte communications. Everybody thinks they know. They probably don't. You have an ordinance, which we're going to talk about, that is standard. Many communities have it, not all do. And they make ex-parte communications. Those are communications that happen outside of these proceedings when you're doing a quasi-judicial, things that you can actually use under certain circumstances. We're now going to tell you what those circumstances are. An ex-parte communication occurs when a party to a case, and that's what these matters are called. For legal purposes, they're a case, a zoning case or a variance case, whatever it is. Or someone involved with the party, a neighbor, a neighborhood, an interested party, an expert, talks, writes, sends an email, sends a text, or otherwise communicates directly to one of you or one of you about the issues in the case without everybody knowing. Well, of course, not everybody is going to know because they can't know because they're not all standing there and watching you do it. So in the ordinary world, where judges actually decide cases as judges, none of those things are lawful because of the unique position that elected and appointed officials hold in the community. It is understood and accepted that you will not be able to avoid being approached by people and talked to by people, your neighbors, your friends, your family, experts, developers, staff, and so forth, beyond what happens at the actual hearing. That's okay if, and here are the ifs. A board member meets with the applicant or an opponent without the public present. That's an example. Attributes of ex-parte communication on local quasi-judicial matters are that it occurs outside of the hearing. It's usually one-sided, opposition or support, does not allow the other side opportunity to respond, can be in any form, written, verbal, electronic, etc. Here's your code section, Article 1, Section 2-2, and it provides ex-parte communications, which in a judicial context, not quasi, would be presumed disqualifying of the judge and require the whole matter start over, are not presumed prejudicial in a quasi-judicial matter if the subject matter of the communication and the identity of the person, group, or entity with whom the communication took place is disclosed and made a part of the record before final action is taken on the matter. Now, listen to me. When even my cities, after having heard the same presentation I've made you make their disclosure, it typically goes something like this. Well, I talked to members of the community that were opposed to it, and I'm going to listen to what I hear tonight. That tells me absolutely nothing if I'm the applicant. And why is it important that I know who you talked to and what it was about? Because how can I refute evidence? I don't know what you were told. If you were told by those citizens that it's going to overcrowd schools, which citizens? What were their qualifications? What studies did they look? I don't know. And I can't confront evidence that's against me and will be used against me in a decision if I don't know what it is. That is called due process. And the failure to properly disclose your ex parte communications, be it with the developer or with the members of the community who have an opinion, is prejudicial to one side or the other. But in all cases, it's prejudicial unless I have the ability to refute it, and I don't have it unless I know what it is. And so when you come to make your disclosures, which typically would be held right before you start the matter, does anybody have any disclosures to make? Is that how it goes here? Right? Okay. So you'd say, this requires you to take notes. It requires you to do more of your homework. I spoke with Jim Jones, John Smith, Debbie Miller. These are the things that they discussed. John was concerned about traffic, and he said he had a study. I talked to Smith, and they said they were concerned about we wouldn't have to be able to get adequate services and response times from the police. And Miller said that she thought it was a great project and couldn't wait to see it get built. Now I at least have something to work with. I can call those people and say, oh, let's talk about that. What is your basis to say it's right? That's just my opinion. You're gone, unless you got some qualifications, and so on and so forth. And it works both ways. If you were talking to the developer who said, this is going to be the greatest thing since sliced bread, and it's just going to be an economic boon to the community, and now the community knows you've heard that privately, they can come say, oh, really? Show me your economic credentials. Show me where a project that you've ever done like this one has done that. But if nobody knows what you're talking about, they can't do that. And so in order to avoid the presumption that your decision is prejudiced by ex parte communications, you must make full disclosure of what the communications were, and it's so both sides get a fair shot that the evidence you hear is something they've had a chance to respond to. Okay? A city official may read, and you on the boards qualify as city officials also, a written communication from any person. However, a written communication that relates to a quasi-judicial action pending before the city official shall not be presumed prejudicial to the action, and such written communication shall be made a part of the record before final action on the matter. If you receive emails, letters, handwritten notes, whatever it might be, texts, as long as they are made part of the record and disclosed on the record as we have these number of emails that are available for public review. You don't have to go through and read each one. Various jurisdictions say it differently. They will say, well, we're going to read each one of them, and that's fine. But instead, as long as they're available so that members of the public can be given them then, while the hearing is going on, and review them and try to address them if they choose to, then you've met your requirement. But it doesn't help if you say, oh, afterwards, oh, here are the emails I got. The hearing's over, right? Doesn't help. City officials may conduct investigations. You may make a site visit. How many of you done that? I'm sure some of you have. Receive expert opinions regarding quasi-judicial action pending before them. Such activities shall not be presumed prejudicial to the action if the existence of the investigation, site visit, or expert opinion is made part of the record before final action is taken on the matter. And I would suggest to you again, that needs to be at the beginning, not the end, in order to be responded to. Persons who have opinions contrary to those expressed in the ex parte communications must be given reasonable opportunity to refute or respond to the communications. Bias in quasi-judicial hearings, big thing. One of the things, by the way, I mentioned the Neptune Beach case that I dealt with. One of the issues there is that one of the commissioners said publicly before ever voting that, I can't remember, I think in this case it was a he, said, I am opposed to large apartment projects, before the project ever came for the hearing. That's a general statement. I don't like them. And one of the things they challenged his decision, or the decision of the group on, is he had stated a bias prior to actually rendering a decision. Ultimately, thankfully, the court said that was such a general statement as opposed to specific to the project that it was not of significance. It was a general commentary rather than something specific to the application in front of him at the time. But would, in retrospect, and after paying me quite a bit of money to defend him, do you think that he would have rather not said it? The answer is pretty clear, although I'm very grateful to the man. I write him a Christmas card every year. So, good idea to keep your opinions about projects generally to yourselves. Those participating in quasi-judicial proceedings have a right to expect impartial decision-making on the basis of the evidence presented. Decision makers should not take a position on a quasi-judicial application until each party has made its presentation at the hearing. Doing so deprives a party of its constitutionally protected right to a fair hearing. And all of that makes perfectly good sense for fair-minded people. Board members should not actively involve themselves in efforts to support proponents or opponents of a quasi-judicial land development action. To do so could subject the city and the individual board member to a lawsuit. In my case, neither of the individuals, there were two who actually made similar statements, were sued, but the city was, and it cost a fair amount of money to deal with it and win. Voting conflicts of interest in statute allows for abstention for quasi-judicial bias. Bias. Not because you don't like it, not because it's controversial, not because you'd rather not weigh in because your neighbors will want to shoot you. That's not a reason for abstaining. Under 286.12, there is a requirement that at meetings of governmental bodies, a member of a municipal governmental commission who is present at a meeting of any such body at which an official decision is to be taken or adopted may not abstain from voting. In the absence of a conflict, you are supposed to vote. That it's a hot potato is not a conflict. I'm so glad I can say that and no one has to fire me because I get to leave it. But now I'm telling you. So you can't say you're not told. You're supposed to vote. In regard to any such decision, and a vote shall be recorded and accounted for each such member present unless with respect to any such member there is or appears to be a conflict of interest. This is the savings clause, what I call the savings clause. If you absolutely are completely flummoxed about whether something that is in your personal life that we might know, a business relationship, a personal relationship, something may be a conflict of interest, then on the spot, you can say, I think there's a concern here, and for that reason of a conflict because of whatever the relationship may be, and for that reason, you either seek counsel from your city attorney on the spot, which may or may not be able to give you the specific answer without more detail, or just say, on the safe side, I am declaring a conflict. But the fact that I don't want to get involved is not a conflict. That it's a hot potato, not a conflict. And this, I've never seen any elected or appointed official prosecuted by the Ethics Commission for not voting, particularly where they thought they had a conflict, even if in fact, because the rules for conflicts are fairly narrow, as some of you probably know, they actually might not have. Because in that situation, err on the side of caution is the better choice. But if you're on the record as saying, I'm just not going to weigh in, you're going to have a problem. Okay? The quasi-judicial hearing standard of review. It's narrow and it's limited. So once you make a decision, whether it's final at the planning and zoning or final at the commission, the review is by certiorari, which means it's an appellate proceeding. But ironically, and for some, this will come as note, it's not to the 5th District Court of Appeals, but it's to the circuit court by a person or persons who typically are trial judges and candidly rarely have a clue about appellate proceedings. So they're asked to be sitting in a capacity, much like you are, in that it's not something they deal with every day in terms of the rules, the standards of review, and everything else. They're much more comfortable dealing with people testifying and providing evidence as opposed to what happens on certiorari, which is, here's this large record I'm supposed to review, listen to the briefs of lawyers on either side, and then make a legal decision called an opinion that says who wins and who loses, and never hear a witness. They're not comfortable in that realm. And that's one of the reasons why, if you can help them on cert review by pointing to the facts that you relied on, you will solve a lot of your own problems. The 3 issues that they look at on that review, if you get to an appellate review, is whether the procedural due process was accorded, i.e. did everybody get the notices that were required? Did the affected parties that were entitled to cross-examination get cross-examined? Did the developer or the applicant get adequate time to say what they needed to say and confront the witnesses? Were the appropriate ex parte disclosures made so that everybody had a fair shot? Second issue they look at, whether the essential requirements of the law were observed. In other words, if you said the code was A and it turns out it was actually B, you got it wrong. If you were right about A, or if it's a marginal call, they generally go with what you said. So you got to be right on the law. That's where your city attorney helps. Whether the decision was supported by competent, substantial evidence. Most decisions that are appealed are on that one. Not all, but most. Petitions for writ of certiorari have to be filed within 30 days or the decision is final. So if you get 30 days beyond whenever the decision that was final was made, you're in the clear, legally speaking. Denials have to cite the legal authority for the decision. What does that mean by that? That means whether it's at the planning board, if that's the final decision, or you, and your staff will clearly know this, they have to write a letter on the issue saying, here's the reason for your denial. That is also an opportunity to provide something that a court can look at later as to why you did what you did. And it will help, as speaking as a city attorney, help a lot in writing or helping prepare that if I don't have to guess based on a very jumbled transcript that I listened to for hours, what were they really thinking when they made this decision? Help a person out. Help Marcia out. Tell her, okay? Best practice for quasi-judicial decisions. Be an objective decision maker. I can't overstate that. Try to forget, although it's not easy and arguably impossible, but try to forget the biases you bring into the room and listen to what you're told and what you've learned relative to that specific decision. Do not prejudge the case. Avoid making up your mind beforehand, unlike legislative decisions, which you're completely allowed to do that. Provide objective decisions based on the facts and evidence presented, not your preconceived notions. Follow your community's plan and the local zoning rules and codes and land development codes. Base the decision on information available to you at the meeting, including the staff report, staff visit, relevant information presented at the meeting, and public comment. Make the best decision possible based on all of the information presented to you. To be an effective board member, for those of you on P&Z, prepare, and this all would apply to the commission as well, prepare well for the meetings. Many times, no fingers pointed, don't know anybody to point fingers at, and wouldn't anyway, it's not polite. But this is not a job where you just show up for the meetings and start learning for the first time what it is you're supposed to be doing. And if you're doing it that way, I respectfully say, you're not doing it. It's not. One of the things that frustrates me, because as an attorney, as a government attorney, I get frequently asked, what do you think the politicians you work for? And respectfully, I say, the ones that do it right really have to work hard at it. It's not easy. The ones that don't do it right are the ones that show up and start asking the questions they've had literally a month since the last meeting to ask and didn't decide to ask until they got up there. And I've heard every justification, none of them make sense. I don't want to be talking about it outside. You have a whole staff. You couldn't ask this with the staff. You couldn't call the city attorney and ask the city attorney why this is legal or not legal. You have to now spend 3 hours getting educated on what I could have told you in 15 minutes if you'd called me beforehand, et cetera, et cetera, et cetera. Am I preaching? You damn right I'm preaching. Why am I preaching? Because I'm doing your city attorney a favor. I'm telling you now, it will help a lot if you prepare yourselves for the meetings. The job of being an elected official or appointed one is hard if you do it right. It's not supposed to be easy. Keep the meeting tempo from same in the beginning and the end. Try not to drag things on unnecessarily, but be fair. Make sure people get heard who need to be heard. Seek to understand each other's positions and opinions. Right now, we're in a culture that I'm sure some of you have observed. We talk over each other, but you don't learn much when you do that. It helps to listen as best you can. That doesn't mean every opinion has the same value or that you will value every opinion the same. But it does mean that occasionally there's a nugget in there, and if you listen, you might pick it up. So do yourselves a favor. Be civil to each other, and the public will be civil to you. I can't underscore now, and particularly now, how important that is. You fight amongst yourselves, you are inviting the same temperament from the public that sees you. If you can avoid fighting among yourselves and insist on good conduct amongst yourselves, you will get better treatment from the public that you serve. Have a bias for action, not for a particular action. A bias to make a decision, not a particular decision. Explain your rationale, but no lectures are required. If you decide, this is the reason I'm voting and here's the evidence, there's no need for moralizing. Who's right or who's wrong? Here's the evidence. Evidence. That's the issue. And you'll help yourself a lot in public perception if you do that. Make your final action clear to the public so there's nobody leaving the room going, what did they just do? I don't know. If there's any doubt in your mind, try it again. More best practices. Make sound decisions and defensible motions. There's no reason why that there shouldn't be sort of a draft, not of the outcome, but a form for motions that are made, particularly ones that are predictable. you could have a line that says, we have decided to grant or deny, circle, the variance. We heard evidence on the following 5 points, and we find that they were met. This was met. Specifically, we heard whatever. Therefore, I move. That's all, and that's enough. Ask applicant if he or she agrees, and if not, why not? Why do I want you to do that as a best practice? Because if the applicant is denied, but here's your rationale for the decision and says, I understand your decision, or I understand how you conclude that, that is also evidence that gets reviewed on appeal. And so then when they say, no, well, no, actually, he was asked that question from the podium, the mayor or commissioner so-and-so asked it, and the answer was, yeah, it's okay. So they had the opportunity, and they waived it. That is a legal argument that can be made and support your decision. So it's a good idea. Doesn't mean you're always going to get the answer you want, but if you do, and more often than not, you'll be surprised how often you will get that answer. It helps to ask. If they have insisted that there's some point that they didn't get to make because they weren't allowed proper rebuttal, there was another witness that they have, and you're still in the hearing, and it goes to that specific point, then there's no harm in saying, okay, we can do it. Obviously, nerves get frayed the longer the hearing goes. Has anybody noticed that besides me? You get tired. It's okay as long as you can reconvene if you're to the point where you're not going to be able to make sense. Even jurors get sent home at certain hours of the night just because they're worn out. Don't be afraid to do that as long as you can reconvene in a timely fashion and everybody can be there. You restate and discuss the criterion to support the motion if needed. Follow competent substantial evidence, not the roar of the crowd. That makes obvious sense. Repeat the gift wrap motion prepared by staff, and that would be along the lines of what I suggested it might say, and then you fill in the blanks as appropriate. If you agree, motions, and because generally staff will say we recommend approval of the project or we recommend denial, and then they will pretty much on a silver platter most times hand you the reason why. And so if you agree with it, then you have your motion right there. Motions are different than the staff recommendation, but the staff recommendation can be incorporated as the basis for the motion. Develop defensible public record based on evidence we discussed. Can't be arbitrary. Denials must provide the reason in writing. We've covered that already. More best practices still. Adding conditions of approval. How many times have, whether it's been probably mostly at planning and zoning, but sometimes here, where you say, well, we would approve this if you would agree to such and such. Can you do it? Well, depends on what it is. If it's an unlawful exaction, and that's a whole other course, no. But if it's something the developer agrees to on the record and it is not arm twisting to the point where it essentially it's this or you're not going to be approved, then the answer is yes. And particularly if the applicant says, like for example, you say, look, I'm good with this except I think you need 3 more parking spaces and I need you to squeeze out 3 more parking spaces if you can do it. And the applicant says, yeah, we can redraw. How he or she talks to the expert. Yeah, we can do that. On the record, you're good. On the other side, I would really like this, but I want you to donate $1 million to the Parks Fund. That's probably an unlawful exaction, and we can discuss why that might be. But for the point of whether there are ability to add things as conditions of approval, it depends. You have to obviously defer to your city attorney for good advice on that, but there are situations where that can happen and does happen, and your code allows for it to happen. If you are doing it, we've covered those things about what makes an unlawful exaction. Does it relate to the impacts of the development? Is it rational? Is there a nexus between what you're asking them to do and the impacts of the project? Is it roughly proportional? In other words, if they're only going to impact this part over here, why are you making them build a road way over there? That sort of thing. And there's a specific statute that talks about the exposure 70.45 for unlawful exaction. But not all asks are unlawful exactions. Okay, why is it not moving? Oh, there it is. I made it to the end. Questions? So now we can be where we started with questions.
Okay, great. So, questions. Let's go ahead and commissioners raise up if you want to have questions, and we'll go, if the board has any questions, then we'll go to the public. We have about 35 minutes.
If I can
Yes,
ask
sir.
a procedural question real quick before I forget
Sure.
it. When we talk about affected parties.
Yes, sir.
would it be appropriate when we send out the notice to include a Willy Wonka invitation to color-code it so you bring it to the meeting and you're predetermined to be an affected
I mean,
party?
if they're within the zone of notice, because that would be a
When
good
we send out the notice that we have a rezoning, and they're within that 300-foot or whatever the area that we determine is
If you appear at
affected
the hearing,
party.
you would be recognized as an affected party. Sure, there's no reason that you couldn't do that legally speaking.
I'm just thinking from, we could spend 2 hours trying to figure out who's affected and who's not. And if we
Yes.
did a Willy Wonka invitation beforehand, that color-coded, it would save a lot of time on that.
It would help, but I will venture to guess that many of them will fail to bring it to the meeting. And you'll be asking the same question.
But we'll
"When did you get them?"
have a list that we
Yeah,
send.
so but the answer is sure. Anything that speeds the process of getting past whether they are or not is a good thing.
Right.
Oh, yes, ma'am.
Could you help us with the ex parte communications both for P&Z and for the commission with regards to social media?
Oh, yeah. I'm glad you asked, because social media was actually a part of the Neptune case. There had been a post. The other person had posted something on Facebook. I hate Facebook. As a lawyer, I hate Facebook. And so, yes, ex parte communications literally mean all forms of electronic communication. I had said emails, and I said texts, and I said, whether it's a phone call or a meeting in purpose or a site visit. But I should have absolutely included all forms of social media, whether that's Nextdoor, whether that's Facebook, whether it's, I don't know, Twitter, whatever. I don't know I don't do them anymore. I'm on Facebook only because I've got a law firm that requires me to be on Facebook because they have to have a personal page to have a business page, which I hate. But in LinkedIn, so it doesn't matter which the source of the information is or how you got it. And kind of expanding upon that, one of the things that constituents, whether they be yours or yours, don't fully appreciate is that when they send you a communication they think is private, whether it's by the direct message or by email, if it's about city business, it's not. So you will do all of your friends and family and folks a favor to let them know that if they start using bad language, threatening language, and even if you may happen to agree with all of it, that doesn't mean it's not public record and that you can protect them from a public records request. So just keep that in mind kind of as an additional aside to the social media aspect of it. It makes it hard because people can delete comments, and you have a job, if you have a personal Facebook page on which business is done, to preserve those. And if you don't know how to do that, you need to get with your IT. But just the fact that somebody deleted a post that they didn't like putting up doesn't mean that it's not a public record if it was sent to you and you saw it. So.
Can I elaborate on that? So you had mentioned it earlier, back to Facebook, and so if we have a meeting in general and then we make a decision up here, and I guess what I'm getting at is if we go to an appeal and afterwards there's a whole discussion on Facebook about what we voted on, is that then, what then happens? Is that violation?
Well, if it's a quasi-judicial, which is what we've been talking about, if it's fully disclosed, it may not be a violation in terms of the disclosure requirement, but it might be a violation in terms of the bias. Because one of the aspects of due process is that you didn't make up your mind. And if, for example, as happened in Neptune Beach, the person went on and said, I'm opposed to these large projects, and I just want all you citizens who keep emailing me to know I'm opposed to these large projects. I was able to win the case and also put my kids through school. I don't know if you want to keep putting my kids through school. They're all grown now. But if you don't want to put my kids through school, better idea is not to put it out there and say, this is my opinion. Because even though I was able to defend that in the context of the larger circumstances under which it happened, including mostly that there was a lot of evidence that supported the decision, the best way is not to do it.
Well, no, I'm saying we vote on it, and then after the vote, we go on, a board member or commission goes on, and, maybe individuals in the area are close or venting, and, one of us comment on it. If it comes back that they do appeal it, so they have a right to appeal after we make our decision.
They could.
So at this point, we shouldn't be discussing it before, after, or any of it, because they can use that against us? Is that what I'm hearing? Correct?
You're hearing that correctly. And it makes the job almost impossible because of the role politically of where you sit. So it's a good thing that you raised it, and so let's discuss it a little bit. First, from a sunshine law perspective, I tell boards, because of the Ponce experience and the LPA thinking they were done and find out they actually weren't done and then they had to be done, that you never know what's going to come back to you. Because literally, we've had projects that were 5 years old come back to us. We had a project that the developer literally turned out to be a crook and committed suicide, but the developer's agreement, which was signed by the city, had a 5-year lifespan, and it was ultimately picked up by another developer. Had they gone on and expressed, boy, I'm really glad this happened, which sounds terrible to say, particularly now that I'm thinking about what happened to the actual developer, but because they hated the development, what do you think would happen the next time that development came through, but with a different developer, and was asking for some sort of a change in a zoning or an adjustment to the PD or whatever it might be? It could be a problem. Now, do I think that people are capable as decision makers, and you all in specific, to separate, well, that was then, this is now, we got to look at it fresh? I think they're capable, but it's going to be a potential problem depending on how you conduct yourself from that point forward, from the time it's landed back in your lap. And so I think there's a line to walk, and I think that line is, if you liked the outcome of the decision, to say, I think that was a good decision. Obviously, we'll see how it turns out over time, or a bad decision. We'll see. Some sort of qualifier is better than I'll never ever support something like that again kind of thing. And it's one of the reasons why, from a political standpoint, not committing until you hear all the facts is a wise choice.
Okay, and then one of the questions I did have, did you want to do it in another way going down the line, or? Oh, okay, was on variances. So when we were talking about variances, it says, you know, it can be granted by the P&Z, or it basically comes before us in height, area, size, open space, distance, or separation.
Sure.
Are those the only circumstances? So, like, we hear a lot of times somebody gets, I'm just going to throw out code enforcement. Somebody gets coded, and the first thing I hear is, well, I'm going to apply for a variance.
Your staff should be able to weed those out. I mean, I'm not saying that staff's perfect, but generally that's the job description. This doesn't qualify for variance. It doesn't meet these criteria. It should, you shouldn't have to be making that decision.
You know, little stupid stuff, you know, like, hey, there's pavers that we got coded for, you know, the sheds in the corner, something like that. Do those qualify even for a variance? Because we're not, no, because we're not talking.
There may be, there's also, and I don't, again, some cities have it, some don't, they have a Board of Adjustment Appeals and various other things, so various other kinds of criterion other than zoning type of variances can be had. And again, depending on what you're talking about, yours sounds like design criteria. Like, I do a lot of CRA work. I'm the General Counsel for the Florida Redevelopment Association. And in CRA work, I don't know if you have a CRA, but generally, in addition to the zoning that applies to the area, they will also have streets have to be of a certain standard, sidewalks have to be a certain width, lights have to be a certain way, et cetera, et cetera, et cetera. Not a zoning, although it's a sort of an overlay of criterion for if you're building in this area, you meet these design standards. So not even a variance in the sense of zoning, but in terms of the build criteria. And sometimes there's a zoning adjustment and appeals board or some similar board, I don't know if there's one here, that might be able to do that. But your code specifically, and the reason I quoted it back to you guys, is so you'd see variances have a very limited role, very limited.
Thank you.
Maritza?
Thank you, Mayor. I would like to go back to the bias in quasi-judicial hearings.
Yes, ma'am.
The last paragraph. Can you go a little deeper into that? It says board members should not actively involve themselves in efforts to support proponents or opponents of a quasi-judicial land development action. To do so could subject the city and the individual board member to lawsuit. Can you
Correct.
go into a little bit more detail on that?
Sure, I'll give you a specific example that I was thinking when I wrote it. Frequently, folks who are, whether appointed or elected, see themselves, understandably, as champions of the people who elected them. Champions. That's not the job. You may think it's the job. That's not the job. The job is that you're there to fairly decide the issues that are presented to you. So, if, for example, this happened, again, Neptune is such a recent example, that's why it's so clear in my head. One of the people on the equivalent of your P&Z, it had a different name there, and two of the people on the commission got involved in going to meetings on behalf of the Neptune Strong organization, which was citizen-based, and providing moral and oral and Facebook support, as we've discussed some of how that support went down. By doing so, they made them vulnerable to the exact challenge that I then got paid to defend and try to get them out of, which had they not done, but made the exact same decision, would have eliminated the claim altogether. That's what I mean. So if you're saying, this is a citizens group that rises up against a big project, and you say, and they say, we'd like you to come speak at our next meeting, my recommendation to you, unless you're particularly good at not answering questions, is that you do not go. So by not answering questions, I'm here to listen, I'm here to take in information, but other than to tell you that I will give this a fair hearing, that's the most I will say. I don't know on less than 3 fingers how many officials that I actually know personally could physically make themselves not speak. It's just not in the DNA. There's a reason you get elected. You speak. But when you go in those proceedings and you speak, you're likely to say something that will come back to bite you later. Until the decision is made and over, you're a decision maker. You're not to be a champion.
Thank you.
Any other commissioners have questions?
Yes.
Commissioner Sosa? No. Okay, Commissioner McCool? Commissioner King, did you have anything? Or do you want to wait?
Commissioner King?
Commissioner Ramos? Okay, I just have one after you, Commissioner McCool.
Okay, sure. I want to speak, and I'm just, I want to start at a very neutral position.
Sure.
Which I think that we all do. That is a job. And I want to discuss preconceived proclivities that someone may have if someone is an elected official. Say that they've been involved with Greenpeace. They become an elected official there. Is that considered bias towards a development if they have a proclivity to be either and I'm just going to use this because this is what we're talking about, either pro-development, okay, or pro-responsible development? I would like to talk specifically about that and being a good public official and staying within the safety of what our legal parameters are. So I would like you to speak to that.
Well, first, the answer, should it matter? It should not. Does it matter? Sometimes it does. What is the way that this should be reviewed? Well, first, I just recently, well, actually, it's still going on because there's litigation that resulted, but for the last almost year and a half, I have been the general counsel for the Orange County Charter Review, reviewing the whole charter. And there were 17 members of the Charter Review Commission. And in that spectrum, 2 of them were former heads of Audubon and/or the Sierra Club. There was connections to what became the one piece of litigation that's now pending, Friends of Split Oak, which is a nice public outdoor, I guess you'd call it a park. I don't know. It's a very big outdoor area that is used in both Osceola and Orange County. It also had people who were, one of them was general counsel for the Florida Home Builders. There were realtors, and then there were community activists. So it's a wide spectrum. They all brought different opinions, and they all different viewpoints. So to answer your direct question, the fact that you have a viewpoint when you walk in the door doesn't matter legally. The fact that your decisions, if it can go either way, tend to go in the way that would be most environmentally sensitive versus more pro-growth, also doesn't matter. What matters is that they're not decisions that are arbitrary and capricious legally, meaning not based on, what's the word of the day? Evidence. So if I come to the table as a Greenpeace activist and say, I'm denying this because, let's use the character of the neighborhood, and I can say, and here's why I think it's not the character of the neighborhood, and I always vote against developments, but I can point to the evidence, doesn't matter.
Yep.
On the other side of it, if I come in pro-growth, and I always vote in favor of development, and I can tell you, here's why it is inconsistent with the character of the neighborhood, and here's why I think so, and there's evidence to back that, that's okay too. You're not a clean slate. None of us are. Yep. I'm not. But what you have to be as a decision maker that bases decisions on evidence, not opinion, on calm reflection rather than hot emotion coming from wherever, whatever quarter. Mad developers, mad affected parties, mad citizens, mad staff. That's just not the way the thing's supposed to work.
Okay, and I want to also clarify from your legal perspective, okay, and answering this question. Can evidence still be subjective?
Yes, and the answer is actually contained in the discussion we had about scale and character and residential character and all that. Because based on what you're talking about, people could look at the exact same set of facts and subjectively view them differently. Yes. And so, yes, it is very possible, and that's why I pointed, I think, to one of the criterion, that one being one, which has more subjectivity built into it. It's not as hard and fast as, did they or did they not meet setbacks? That's a measurable. Yes. Certain things are not measurables. So then you look at, okay, if they said it didn't meet or it didn't meet this particular criterion, what evidence did they hear? And as long as there was some and it was competent, then you're good.
Okay, and my last two things here, and I'm sorry, but I just want to be clear.
I'm yours for today.
Okay.
Or at least until noon.
You have done, from what I understand, extensive historical work on comp plans,
Yes.
charters, things
Right.
like that. And I want to ask you also regarding interpretation of a comp plan or taking into consideration a development of any sort, okay? A rezoning, land use change, anything that does with development. And I wanted to speak about the interpretation of the comp plan. Myself as a commissioner, when I see a development, is it my job to take the interpretation of the whole of the comp plan as it is regarding the city and the development of the city, and doing fact-finding within the realm of the whole comp plan, or am I supposed to be more laser-focused and focused only on what the staff is presenting me? What is my job?
Well, you have asked a very, very broad question because the comp plan itself is very broad, and I will do my best to guide you through it. In most contexts that we're going to be talking about comp plan, it's going to be a proposed amendment, whether it's proposed by staff or by an applicant. And in that regard, comp plans have to be internally consistent. And within the comp plan, there are three areas that are focused on most: goals, objectives, and policies. And you've seen all three of them in your plan. I don't even have to look at your plan to know that they're all three there. And there are elements. There's a housing element, and then there's an environmental element. And I don't know what the names are for your particular elements, but there's 4, 5, 6 different required elements. And your plan's supposed to speak to all of those things. And within those things, there are things that cross over. So that if you're only looking at the housing element without looking at its impact on the environmental element and your goals and objectives and policies in environmental versus your goals and objectives and policies that are only in housing, then you're being too, in my opinion, laser focused. On the other hand, if the question is focused just on housing alone, as whether this many units per acre is better for this specific area than that many units per acre, then maybe all you need to do is focus on that. But again, it's contextual as to what is it you're asked about. Because clearly, the idea is that whatever you put in your goals, objectives, and policies for all the elements, they are supposed to the extent possible, harmonize with one another.
I'm good. And then I just wanted to, the last thing is bias being disclosed in prior decisions? I just was expounding on what the Vice Mayor was talking about. It is not legally considered bias if someone has on a prior issue, it might not even been a city issue, but it might have been a relevant issue, have disclosed that proclivity on a social media. Can they be excluded from bias, or is that considered bias if someone
A decision maker or a member of the public?
A decision maker that was prior not a decision maker and has disclosed bias on a decision made prior to them stepping in a a lawmaking capacity or interpreting.
Yeah, there is no list of disqualifiables. Well, I used to be in this, I mean, I'm not going to get too far out there, but some very objectionable social groups that are, we could all come up with our own idea of what that qualifies for, would not disqualify you from serving. And if you can serve, you can vote, and as long as you disclose what needs to be disclosed vis-a-vis ex parte, and you make decisions based on evidence, whatever you bring to the table, even felony convictions, believe it or not, depending on whether they've been expunged or otherwise pardoned, is irrelevant to whether you can serve. And if you can serve, you can decide. And if you can decide, then you should be able to do everything that I've taught today.
Thank you.
Okay, any other commissioners have questions? Because I just wanted to go back to the variances that you had. And first of all, Mr. Peters, if you can provide the commission and the board with a copy from section 110-1103A in parentheses, however, D is the written petition demonstrating the special conditions.
Those are the 5 conditions.
Those are the 5 conditions. If you can, or the city attorney can provide that for us, because I think it's very important that that be up here on the dais. Those 5 conditions be listed, that we have ready reference, that is what we're dealing with for a variance.
Yes.
In terms of someone coming in, like what you said, Commissioner, or Vice Mayor Bradford. So the one question that I have for you on applicability of variances, you said variance standards, and then you talked about hardship and so forth.
Correct.
And economic or financial hardship is not exceptional. Inconvenience, aesthetic considerations, physical handicaps, personal preferences, or the disapproval of one's neighbors likewise cannot, as a rule, qualify as an exceptional hardship, even if the alternative is more expensive. So when we're talking about physical handicaps,
Okay, of the individual or the property? Because variance is to the property, not to the individual, you understand?
Right, but if someone is asking for a variance to the property because of a physical handicap,
then perhaps, under the circumstances which would require more evidence and facts than I can actually put here, there may be a case where that could be considered, and that's why it's worded that way. It says, what does it say, typically or usually? I forget the word.
it says inconvenience, aesthetic considerations, physical handicaps, personal preferences, or the disapproval of one's neighbors likewise cannot, as a rule, qualify as a rule.
So
Cannot qualify as an exceptional hardship.
No. The reason I would leave the room specific for the example you cite is because of ADA.
And that was my question. So
that's something where you, at that moment for that specific thing, and certainly long before it ever gets here, that should be a staff consideration.
Okay.
To make a recommendation.
Okay, and the last question that I have, going back to the quasi-judicial hearings on a land use, we're always told, and Mr. Peters and Mr. Paradise and Marcia, again, we're told when we look at an approval or a denial, for example, for a change to the comp plan or a zoning, that we have to follow the criteria. The criteria that the applicant has to.
Yes.
And we have certain things.
For the specific, whatever the category of zoning is they're looking for.
So those criteria, this is what we've always been told, that we need to look at those and state a reason if we're going to deny this, if the applicant has.
What does it not meet by evidence? Correct.
I'm sorry, yes.
What does it not meet based on the evidence?
Yes, what does it not meet based on the evidence? So can we also have for reference those points by which we are to judge these things that come in front of us?
I'm not going to speak for Mr. Peters, but what I will tell you is this. Those should be in the staff report. In other words, the staff reports with which I'm familiar says, let's say it's PD. That's a very common one. So the PD is being applied for. Project includes mixed residential and retail and whatever. And point 1, does the da-da-da-da-da, and then the staff comments. Point 2, da-da-da. Those should be, and typically are in the staff report.
They are, yes.
One by one. So there's your answer. And if they say, in a staff's opinion, it doesn't meet one, then you also know that it meets or doesn't meet whatever it's got to meet. Rezonings, whether they have to require, and this is, I don't know about your code, but often like variances, they have to meet all of them. In some cases, they may only have to meet most of them. I don't know what your code requires, but whatever it is, at the end, the summary portion of the staff report for that item should be, therefore, the staff's opinion is it doesn't meet the criteria, or it does. And the difficulty I mentioned earlier is when staff says it does, the developer says it does, and even though there's a lot of opposition in the community, no evidence says it doesn't, your hands are tied. And so that's why it's important for the community at large and affected parties in specific to bring more than opinions to the table, and that's why it's important.
And so when there's a motion for denial on, for example, any such topic that we've just discussed, we have always also said, I am voting for this because it meets the requirements. I am voting against this because, and we're stating something.
It's not required that you do that, but it is required that a letter go to the person and tell them why you denied it.
Okay.
And so why not tell them?
So that's a good practice.
That's good practice.
Okay, thank you.
I want to add something else, because I focused, as I have done in all of these presentations, on the variance requirements as it applies to specific land use issues and zoning issues. In your code, as in others, there are other types of variances with different criteria, like how you handle wastewater, I think was one I saw. I can't remember the others, and it says, all you have to do is put the word variance into your search for your muni code, and you find a whole lot of code sections about how you variance this thing or that thing or the other thing, and they have their own additional criteria. So what I talked about are the things that apply to the variances that we said about setbacks and so forth that are spelled out there. There are other parts of the code with different criteria or additional criteria.
Okay.
Madam Mayor, if I can jump in here. I was doing the same research that Cliff was doing with regard to variances, and unfortunately I sent him my stuff late. He was already done by the time I saw his notes, but one of the things I noted, because I've had conversations with several of you all regarding specific variances and stuff for parking or trailers or what have you. And I know I've had a conversation where the gist of the conversation is, well, our code keeps changing. Well, based on what you heard today, you now know why our code keeps changing. We have a very strict standard to get a variance. Money's not an object. If putting a trailer to the side of your house requires you to build an 8-foot retaining wall and redo the eave on your house, that financial restriction is not a basis to go by. So then, what commissions in the past have done is they go, well, that's not acceptable, and they change the code. So when you see things like parking criteria change over the years, that's why, because it usually was probably driven by some variance requests that we couldn't go with. And I think Cliff will agree that our variance requirements are pretty severe here.
And typical as well. What's also typical, however, to your point, is that they tie hands in a way that many elected officials and some appointed find uncomfortable. It's uncomfortable to tell a neighbor something that seems like a no big deal to you, but you're going to have to say no under the code, no. So what happens most of the time, even to people who've heard my lecture, is they ignore it and can immediately do what they're going to do anyway, which I don't care, I sleep at night. But the reason it's important to know is that on the times you do get called out, everything I'm going to tell you is going to come back to haunt you if you did it that way. And so it's important, therefore, that if something is common enough, that enough people are requesting a variance from it, to your point, John, that you change the code. Don't give up on the variances, change the code.
Okay, commissioners, we're good here? Then board members. Just go right around, whoever has a question. Mr. Pfeffer?
I have a process question, I guess.
Yes.
Can you use your mic too? Thanks. Sorry.
It's difficult. I have a process question. When I was in zoning in Connecticut, we were the group that made sure that all the I's were dotted and the T's were crossed, so that when it went to the council, they didn't have to get into technical matters. We were the technical review of the project. And sometimes when you look at the staff report, you see they made judgments, but you can't feel whether those judgments were right. I mean, there was a project where there was some water, and in order to, they changed the density so that the density was less near the water and higher elsewhere, and they made some decisions. But I was personally uncomfortable because I couldn't feel it from the report. And I'd like to know, is there a process where site visits can be organized before the meeting so that we know what the hell we're talking about?
It is a great question, but as soon as you throw in organized, the answer is no. And the reason why it can't be organized is because if more than one of you are together at the same location, that is a sunshine meeting. And what that means is that you have to have notice, minutes kept, and public attendance, and you can't. And so you can go on your own, as we discussed during the ex-parte section, as long as you disclose that you went, what you talked about, what you learned, that it was evidence that you're going to consider as you consider the rest of the case. But what you cannot do is say, hey, let's all get in the car and go out there and take a look at this thing. As soon as you get in the car, it's a meeting. And now you're violating sunshine law, and unless you want to go to jail, I would suggest you don't do it.
But can we have it so that somebody from the staff or the developer is with us so we can ask rational questions?
Well, yeah, you could go meet with the developer on the property. You could go meet with staff on the property if the staff is able and willing to do so. What you can't do is take anybody else on your same board or commission. You could go, in theory, although not recommended, with another member of the council because you're not on the same board. But you can't go with another member of the same board.
I have a question that's similar to that, and that would be, we obviously would have to disclose if we do a site visit. Well, what if you know that a matter's coming before the board and you take it upon yourself to go back and look at and watch the commission, Deltona Commission, and even the county resolve issues that are similar to that nature, or maybe even dealing with the same developer who's maybe coming back before you again, and you sit there and listen to the evidence that they're presenting to those bodies? Is that something you would have to disclose when the matter comes before you as a board member?
Well, the answer is yes, if what you're listening to is influencing your decision, which means that you consider it to be evidence, which means it would have to be disclosed. Because if it's not influencing your decision, like, don't ask me how many meetings I've attended in the last 20 plus years of doing government law, because I've been practicing law 36, but it's a lot. And so everything I'm telling you today is influenced by some meeting I saw or something I was done or some case I was involved in at some situation over that time. And they inform what I'm going to tell you and the way I'm going to tell it to you and why I'm emphasizing certain things versus other things. Okay. But in terms of the next decision I make, in terms of whether something should or shouldn't be approved, if I was to make a decision, I silently make them in my ears, no. So that's really, it's like almost a personal conscience question. But if, for example, you went to see a presentation of the same developer, a different body, related or similar project, or maybe even the same project but a different body, and that was influencing your decision, and you didn't disclose that to the rest of the public, particularly if it was in favor, they said, well, wait a minute, how am I supposed to know that was because next thing happens, sometimes accidentally, is, well, I went and I saw Mr. So-and-so make his presentation to the county commissioner of the St. Johns River Water Management District or whatever, and I was very impressed by this expert or that expert, and therefore I think this is not going to be a problem, and the rest of the audience goes, what? So it is not something where I can say with a broad brush, no, you can't or shouldn't do that, but what I can tell you is what I've said all along, which is it evidence, and are you going to consider it such, and if that's true, then you better disclose.
Thank you.
Ms. Northey, I think.
Yeah. Two quick things. Is the evidence that's presented to the P&Z board, is there an expectation that that evidence goes forward intact or updated, added to when it gets to the...
Depends on whether you're the final decision maker subject to appeal or whether you're advisory, and that depends on the issue. In some cases, you have final authority. In other cases, they go to you're recommending and it goes to the body. And so I don't know, but you'd have to go by decision. It is final if it's the next, if it's final with your board, then there's no more evidence unless the code specifically says so. And what they get on an appeal is what you had. They're not allowed to come in and say, well, if they had brought in this evidence or that evidence, because it's not a brand new start, it's not a do-over, it's an appeal.
Okay.
But in some cases, depending on the code is drafted, they use the words, and you may have seen the words, de novo. De novo review means it is like they get to start over. And so new evidence would be okay. So that's how you make the distinction.
Okay. And then the final question is, this board is subject to sunshine, that board is the
Yes.
commission subject to sunshine. But I didn't think I heard you say there was a prohibition. You didn't encourage it, but there was no prohibition between a board member speaking to a commissioner on a specific item?
That is true. However, to the extent those conversations, again,
They become ex parte?
they could be, because particularly if they amounted to evidence. And the conversation, for example, I don't know anybody's background, but for the sake of discussion, I'm going to appoint you an appraiser, because I don't know what you are. But today you're an appraiser. And so you meet with the mayor and say, hey, this project's really going to screw things up. Well, you're now more than just a board member, and y'all can talk and not be in violation of sunshine and still give her something she's going to have to disclose, because it's evidence, or potential evidence. So that's an example of what I'm talking about. It's not a sunshine issue, they're on the same board, but it may be a disclosure issue and an evidence
Well,
issue.
but disclosure is not a bad thing.
No, that's the whole idea.
Yeah. Okay, thank you.
Okay, any other board members have questions for Cliff?
Okay, can you hear me? This is regarding, for instance, the connection between the Planning and Zoning Board and the Commission members. When it's a process, like and it's an application, then come to the Planning and Zoning Board, there's certain criteria. It's supposed to meet certain criteria. So that's give you the approval or the denial. So the criteria are taken based on the facts and the code criteria. When it goes to the commission, maybe fall in the same categories, or maybe there should be more for like the same approval or denial. Because or for our experience, we see that, like, for instance, when they come to the Planning and Zoning Board, we can maybe deny based on criteria this project, and when it goes to the commission, they get approved because they don't consider like the points of denial. So how we can manage that conflict, or why is the nature of the conflict, or it is not a conflict at all?
Okay, I think, here's my understanding of the question. If I get it wrong, tell me. You said a decision comes through P&Z, whatever the decision is, and it's made, and the reasons for denial or recommendation are spelled out. And now, as a recommendation, it's now in front of the commission, and the commission sees the evidence differently. Well, certain things are undebatable, right? Did it meet the setbacks? Is it under the height requirements? Is it whatever else it's got to meet? Those are undebatable. But there are others, as we discussed, like neighborhood character, and even things like how a traffic report is reviewed if there are multiple traffic engineers. You deny based on adverse traffic impacts, but there's 3 engineers, and one says it's fine. And they say, we like this guy. We don't think that one is any good. You still end up at a different place. You still made a conscious decision, and both of them make a conscientious decision. That's not a problem. That's the system. One of the things that I like to use to kind of underscore this example, because this conflict between boards and commissions is very real and it's very normal, is it used to be a time when we read books, and lawyers used to advertise their services by standing in front of a wall of books. If you're old enough to remember, I'm not old enough to remember because those books used to be in my library. Hundreds of books. And the idea to be conveyed in these early law commercials was that, see how smart I am? I got all these books back here and I know all this stuff. But here's the truth. Everything that's in those books, I'm not joking, everything in those books, those are called case law books, are mistakes. Mistakes made by trial judges, essentially, like you, reviewed by somebody else who decided that they knew better because they got the law wrong, because they misunderstood due process, they did whatever. If you look at it that way, to answer your question, it is very possible you will never agree on who was right. That's what all those books prove. but they get to be final until someone tells them they're not.
Okay, any more questions from the board? Do we have any members of the public that have, that wanted to ask some questions? And then we need to wrap it up. Are you okay, Mr. Shepherd, for going?
Good.
Okay.
It's going hard. I mean, I want to make sure I don't.
Do you want me to get to the mic? Walk around the other way.
Yeah, there should,
Do what?
do we have a mic for the public?
Turn this way. Turn.
I appreciate this opportunity. Thank you, Mayor, for
It's on.
thank you for allowing me the opportunity to ask a question. You were describing the process where, at the minimum, a proposal to change zoning, thank you, has to meet the comprehensive plan.
Yes.
At that point, is the process over? Or is there another step involved in which the commissioners or the board could, within their discretion, choose that development is not appropriate at the time?
Well, that is one of the easier questions I'll answer today. Everything must be consistent with the comprehensive plan. If it's not consistent with the comp plan, it's game over. But it's at that moment game over. Why? Because comprehensive plans can be amended, and as I said right at the beginning, what is the area in which you have the most authority to make amendments?
Legislative.
The comprehensive plan. And that's the area where affected parties, the public, developers, have the least amount to be able to do anything about that. So let's suppose, in your example, the comp plan said no, and that means the zoning is done, we're done. They can go back and change the comp plan so that's no longer the case. That is always an option. Now, whether it will then delay the development to the point the development goes away, possible. Whether it creates, you know, some other kind of political issue, that's outside the realm of what I can discuss. Comp plans can be changed. Zoning can be changed, but subject to actual rules and evidence. Comp plans, you don't need evidence. You just need to want to.
Just a quick follow-up, if you don't mind. So even if it meets the comprehensive plan, can the commissioners still say no about the specific proposal?
About the zoning.
About the zoning, yes.
If it doesn't meet the criteria with evidence on some point, even if the evidence is conflicting, as long as there's evidence on the point, the answer is yes.
Terry Ellis?
Hi, quick question. We talked about written communication from any person. However, written communication that relates to the quasi-judicial action pending before the city shall be presumed presidential or prejudicial, and written communication shall be part of the record before a final action. And I know that you made a comment about you don't have to read them, but they have to be available
Yes.
during the hearing.
Right.
Okay, and so so I wanted to get some clarification there because I know that in the past that has not happened. So the comment has been made that the emails, for example, are part of public record and anybody from the public can order them. But but you made a comment that they need to be available during the hearing to the public. Is that right?
Yes. It is considered a best
That
practice,
sounds
and
like a change that
it is considered a best practice and also something that I think is required for due process. And let me explain again why that's important. The whole idea of allowing ex parte communication for all the folks here is so they can get a sense of what's going on in the community that will impact, so they can physically go see it, so they can talk to their friends and neighbors and actually engage in the conversations, which would be almost impossible not to engage in without seeming antisocial. So at a certain level, the legal process recognizes the dynamics of being a local elected official or a local appointed official. The way they solve that problem is by requiring those folks, local appointed and elected officials, to say, hey, this is what I learned outside of this proceeding. And the only way that that disclosure is helpful to people like you or a developer or anybody else who has a stake in the matter to address it is to know what it is. And knowing after the fact doesn't solve it. So saying, I'm handing all my stuff to the clerk is fine at the beginning, but then the onus shifts. It would be great as a practices matter if it was, we've got copies of all the emails and so forth, you know, and that are available. They're here. You can come up and grab them. They're in stacks or however you want to physically do it. And sometimes that's going to be crazy because there's going to be a crazy amount. But whatever it is, that's preferred best practice. As to what I believe is required, if the clerk has them and they've been provided to the clerk in advance, then the burden shifts, in my judgment, to the member of the public or the affected party to say, I want a copy, and until I see it, I'm not going to be able to go, and so you're going to have to give me the time to review it. In which case, then the chair, the mayor, is going to have to make the decision, okay, we'll take a X amount of minute recess. Anybody who wants to read the emails or the whatever we got, that's what you got, and then you can prepare. But one of those things has to happen. If there's a complaint later and it didn't happen, that's a complaint that's going to be much harder to defend.
Thank you.
But that also includes email, social media posts.
That is correct, and that's why all of those things, wherever you get them from, have to be brought in and provided.
Duly noted.
Okay.
Social media posts, ladies and gentlemen. So the burden is, let me just go to that question. So let's say I post something on social media, which I do not, but I would say, okay, I don't believe in this project, or I think, or come on out, you need to come public and talk about this project, for it, against it, whatever. Right. The burden is on me to provide that so that it can be printed out and everybody can see it, that Mayor Hertzberg has encouraged the public to come and talk for the new ordinance, or not ordinance, but the zoning or the thing.
Whatever it is, yes. And that would be the ways, if I'm advising you, if you were my body, I would say, make it easy. As soon as you see it, forward it to the clerk. If you need to screenshot it, but get it to, don't wait till the meeting, because then now the clerk's got a hands full. Her or him, I don't know who's got it. But the bottom line is, when I say, well, what do I do with these text messages? Send them to someone who's not you, so you don't have to worry about them anymore? What do I do with these emails? Same thing. What do I do with these social media posts? Same thing. I don't want to overburden your clerk, but you really want to see an unhappy clerk, try to do it all the night of the meeting. Am I wrong? Am I missing something here, Joyce? Okay.
Okay, thank you, sir.
Can I ask one other question? You've given them a lot of information with regards to ex parte and how it's supposed to go. And quite frankly,
I've done a more abbreviated version just because if the commission wants to go this route, we're talking about a much longer process, and that's fine. But could you also address the fact that if you have the stack of emails and you have posts on Facebook and everything else, and the applicant wants to go through it, or another party, that they have the right to cross-examine the commissioner who has, and you didn't really address that either. We've never had this happen, but the more information that's going to come out in the process, as you all seem to want to go in that direction, we're going to have the applicant or other affected parties perhaps wanting to basically voir dire the commissioners.
This is true. And so let me suggest to you how this typically goes down when it occurs. And it's a rare occasion. Most people do not take advantage of the opportunity. I'm not most people. If I'm representing a developer and I think you have done things that I need to know more about, I will be asking you. But most people aren't me. And also you should know that developer lawyers are not generally known for wanting to get on the bad side of the people they have to go before all the time. So most times you'll get a pass. That doesn't mean you should assume that most times are always going to be the situation. But how would the examination go? And it varies from lawyer to lawyer. Mine would go something like, well, ma'am, could you tell me, you said you spoke to this neighborhood group and about this traffic issue. Did they tell you they had a study? Well, no, they just said they thought it was bad. Okay, well, did they tell you where they'd consulted with any experts? No. So do you agree with me then, ma'am, that that's just opinion, it's not based on anything? And if you disagree with me, we're going to have a further discussion. But if you agree with me, then we're on to the next topic. And so that's how it would go. It's not like Perry Mason, isn't it true? It's more like I need to get to the point because I can't figure out what I got to refute if I don't know what it is. And so that's the purpose of cross-examination. It's not to make any of you feel uncomfortable, or any of you feel uncomfortable, or anybody out there feel uncomfortable, or the developer feel, or staff. It's so we can understand what is the universe of evidence if I've got to make the case that I have to refute, whether I'm on whatever side I'm on. And if I don't know, I can't refute. So that's the spirit of the cross-examination. It's not to say, gotcha. It's to try to figure out, okay, what is it that you think that I think is wrong that I can try to amend? I may not be successful, but if I know it, how many of you think I could actually change your party affiliation with me telling you something today? Don't raise your hand. It's probably not going to happen. But at least if I know it, I could talk about it. Now, it's not relevant to development. That's why I brought it up. But the point is, but I got to know it. So if it's something germane to the decision, party affiliation is not, but if it's germane to the decision, I got to know it in order to at least get the opportunity to make the attempt. That's all.
Okay.
People that are going to be cross-examining anyone are either the people that are up here, people down there in their board, or the people in the audience who are affected parties only.
Most of the time, that is 100% true.
I think that's important, because all of a sudden it sounds like, holy smokes, everybody in the world should be cross-examining.
No, only affected
everybody else.
parties, and that's why the affected party thing is, you're 100% right. Only affected parties, and then that's why that affected party thing is so important, because otherwise meetings would never end.
Right.
And you'd have a whole lot of amateur Perry Masons out there trying to make a point, which isn't the point. And you may have it anyway, even with affected parties on big enough projects, but it's at least a more defined universe. And frankly, most people don't really feel comfortable standing at a podium for hours and hours like me and talking. So they really prefer someone else to do it. And so what typically happens, if they're prepared as an affected party group, they designate, and I know you've probably seen this, a spokesman or spokesmen, people, and experts, and then they sit there and say, do you all agree with me? Yes! That's generally how it goes.
Okay, any more questions? Anyone from the public? No? Ruben?
Just a comment regarding the ex-parte communication and the possibility to be sued for the behavior or the way you manage the communication, like public media and every single thing. My suggestion is like when you're in a position, and like it's a public position, in which you basically, your opinion is very important, and my recommendation is like social media is only for like, like to participate to other people, your opinion. But when you're a public servant or even an appointee, your language needs to be controlled.
Yes.
And this is the reason. So you don't need to be worried about like expertise or you can sue you for that or how you express your opinions. If you do it like a professional with a, the right way instead of a political way. Oh, I don't agree about this because I'm against this and this and this and this. In order to keep the people happy. But when you're making a decision, which is basically a lawful decision, I think you need to control the language and how you communicate. Like me personally, I don't have any social media, and I communicate with more people than I can do in social media. But it's different ways to communicate. So sometimes people think that like social media is only for friendship and everything. You can say whatever, but it is if you are a political figure or you are a represent a city or the law or something like that, you need to be careful about your language.
I think I would put it this way, and it might be, I'm certainly willing to stay as long as you want, but it might be a good place to end to say this. For elected and appointed officials and members of the public, words matter. Mind your words.
Okay. Any more questions? Commissioners, board members? Yes.
Just want to thank you for coming out and educating us.
Yes, ma'am. Happy to do it.
Mr. Peters, any commentary?
Yes, I want to thank Mr. Shepard, and I would like to everybody give him a hand for what I think has been an outstanding presentation today. I know I have learned a few things. I'm surprised I learned, but I think we all learned something. Ms. Northey has been on boards most of your life, and she confided me back in the back that she learned a few things in the morning portion, so, well, now afternoon. But yeah, I want to thank Cliff. This is the first of several of these type workshops that I had promised you all. The next two that we're looking at is working with the League of Cities, whom Cliff also works with on ethics training that's required every year. I am working with the League of Cities to do the ethics training for this area of Florida at our center because we'll be able to social distance, and I'm hoping I can get Cliff involved with that.
No. Okay, well, I'm in.
And then the other one is going to be an important one. I'm trying to figure out the best approach, but we've been getting a lot of emails regarding records, and I think it's imperative that we have the discussion, legal background on what the records laws are and the whole approach, because it's imperative that moving forward that we get this under control, because I know I'm spending way too much time. Joyce is buried in records requests, and we need to get a comprehensive record policy in place that we are comfortable with. So that's what we're looking forward to. I want to thank the people that came today. Especially want to thank Ms. Buteland from DeBerry. I know they, I think the mayor is watching from what I understand. And we're going to put it out there to everybody in our fellow communities that this will be archived. Ron and I talked about having certain staff members watch it after the fact, because I think it has been a very valuable exercise. And in fact, I think it's going to lead to some more discussion about how we handle ex parte communication in terms of getting the records in, and what's an appropriate format for that. So I appreciate it again, Cliff. Really,
pleasure.
You did me proud.
Thank you for letting me come and speak to you. I appreciate it.
Okay. Thank you, sir, and we are adjourned. Have a good weekend, everyone.